Yes, Mr. Pome. You are the opening batsman today. So,
I beg to
no
mention,
adjournment. It should be 6.
I beg to mention item number 31 and 32, my lord.
31, 32.
My lord.
On the prayer of Mr. L. Pame, Learned Counsel appearing for the respondents and not objected to by the Learned Counsel for the petitioners, appellants, registry to list those matters
After vacation.
after 4 weeks or date to it. Okay.
I love it.
Marvelous.
Yes, Mr. Murray.
My
Been a
lord,
long time. Been a long time not seen you.
Yes, my lord.
Hmm.
So, my lord, criminal petition number 158. This may be, my lord, taken up together in item number 19. The similar matter has been listed in item number 19, my lord.
That
Same-
gas cylinder, stealing
same
of gas cylinder.
My lord. All right.
Today, along with 19.
May I please, my lord? My lord, I beg to mention item number 23 and 24. The conducting council is out of the station, so matter may be adjourned for that day. 23 and 24.
What is here? Witnesses have already been examined.
Yes, all witnesses have been hostile, I think so.
Be that as it may. Finish it off there. Wait, quashing. Who is the counsel?
KSC.
Huh? KSC. Where is Mr. Kamduk?
Kamduk is here, but he is not arguing this matter. KSC will be arguing this matter.
What happened to him? What happened to him?
He went out of his station. He went his home.
When is he coming back?
After vacation, you know.
Oh,
After
so.
Sorry.
Huh? By the time there will be nothing left here. 23, 24.
Yes.
On the prayer of the Learned Counsel for the petitioner. Adjourn. After 4 weeks.
Quickly obliged.
On a request, on a prayer made on behalf of Mr. K.A.C. Huh? Yes. Yes.
May I plead your lordship? My lord, in this matter, my lord, last time, my lord, your lordship has asked me that I have to clarify about the cadastral map, which the deputy commissioner has mentioned in the impugned order saying that it is under the cadastral map.
Page 102.
Yes, my lord. But my lord, in this case, my lord, cadastral map and township camp has it has come up in 2005 only. Otherwise,
Show me your existence before that.
my lord,
Something. Give me something to
Yeah.
hold on.
I can just show you this the census because village is called a Nerumbro because that area comes under the Nerumbro village. Nerumbro village.
It's is it on record? Census?
It's in 1971 census, my lord.
Where?
Yes, I'll just show that.
Page 45.
Yes, my lord, I will just capture that.
This is nothing. This is neither here nor there.
Because my lord, that time, my lord, town was a Teju. It's around 263 kilometer from Anini. When the town was not created, I mean.
Who is the predecessor of Gita Mihu here?
Yes, I will
Page
just show-
44?
Yes, my lord, I will that.
Mikheno Mihu.
You can name my lord, page 44. Page 44. This is the census, my lord, of 1984. This is little bit the spelling correct wrong is there. E6.
See, this is the problem. How can we place reliance on something which is not very clear?
This is McKinney Mihu, my lord. My father is correct, my lord.
Have you made any statement to that effect in your writ petition?
My lord, I have one more. There should be one more figure, my lord. But the deputy commissioner has not disputed, my lord. When
See, there was never a proceeding for land acquisition either under the 1894 Act No,
Yes.
under the 2039.
Yes, well, I will just show you, my lord. It was under the occupation of Assam Rifle, my lord.
55.
Yes, my lord. I will just show you that Assam Rifle, they have, it was never
No,
counted.
no. If
Yes.
that land of yours, you were never there from 55.
No.
They had ousted you.
No, my lord, that area is still adjacent to that ITBP. The land is still occupied by these petitioners' villages, and recently only they also paid compensation, my lord. That is, they have it.
I'm not saying whether you are residents of that area from 1955.
Yes, my lord.
Then where is the question that your land, you were ousted from the land? That land was never, your land is with you.
No, that comes under the community land, my lord. Village comes under the village land, my lord.
Okay, that land, say land A, whether that land is under your possession or under the possession of the Assam Rifles from 1955.
1955, they have taken from the villages, my lord.
Villages.
Villagers saying that.
Where is that taking over from the villages?
That record is not there, my lord. Because we have.
From 1955 till that 2011 matter, there is no grievance raised.
No, my lord, we have said in the petition, because there are two processes, my lord. Land has to be taken in two ways. One is the donation, second is through land acquisition. So
Be
now
that as it may, it was taken forcefully, let's say. But what did you do from 55 to 2000?
they are all illiterate villagers, my lord. They haven't asking for the compensation. They only promise that we'll pay compensation. And many families also died from the villages, my lord. That is the situation, my lord. So, my lord, in fact, I'm trying to convince.
Yes, madam. What is your stand?
No, whatever is in the order is
Order.
there. Lord.
We find it very difficult in absence of.
Okay, nothing more to submit. Lord. Here in the last para, the land in question was possessed by Assam Rifle from 1955 to 2005 and transferred to ITBP in May 10, 2005. On 26 August 2003, the land.
No, we have read it.
allowed.
We have seen it.
But we are not disputing that it was in the possession of Assam Rifle, my lord.
Now we are saying that.
But
the
my
land-
lord, I just want to place one judgment. That judgment also, my lord, you're aware of that. It says that they cannot claim on the basis of the adverse position. The government cannot claim.
There is no question of adverse position. If the land is government land, there
No,
is
that
no
it was never government land, my lord.
there cannot be a acquisition proceeding on a government land.
No, it was never government land. Government land came in 2005.
See, this land was taken over, maybe it's a barren land, taken over.
But in fact, that land was taken over the government notification in 2005, my lord. And 2005 notification also, they have never followed the land.
And this land is not of Gita Mehim or her
It
predecessor.
belongs to the villages only, my lord.
Villages, where are the villages before this court?
So he represented.
She cannot.
My lord,
If there are persons interested, they should have been here before us. How can we now direct Gita? Who are the people? How can we know who are the people? Who will they pay the compensation
My
to?
lord, we can inflict.
This is not done. So second point. Third point, before it comes up, take a call. Otherwise, it will be foreclosure for you. Subject to appeal.
Otherwise,
Now,
my lord,
Gita Mehu cannot be the owner of that land. It's some villages somewhere.
yes, that I.
So that where are those villages?
Then, my lord, there can be, I mean, my lord,
Today we will not permit.
otherwise, my lord, lane delay latch is also not cover, is in effect.
Again, I forget everything. I only want a connecting thing. That's all. I give everything in your favor. This third last paragraph, I want an answer. That's all.
My lord, which paragraph, my lord?
Third last paragraph of page 102.
102. The 102, my lord.
This, mind you, this was done after taking into account all the documents you had produced. The land in question was possessed so and transferred to so and so recommended for allotment of so as per government letter number so. All the deputy commissioners were directed that the government land remaining unused under so shall be reverted back to the state government. Recommended allotment of 49 so, the final town notification published on so. The land under challenge, sir, this final town notification is a subsequent act. But before that only, the land was earmarked for some other purposes.
No,
And you nowhere figure, even distantly,
my lord,
your only thing is a presumption.
Dalab, there was the system called Dalab, but then it also, they have removed this system. In fact, so that they have recommended, and we also filed a representation saying that Dalab, we challenge Dalab, my lord. We challenge the Dalab recommendation, and then, my lord,
Where?
in 2017, my lord.
Where?
That was impugned in the 2007 writ petition.
That 11.
2000, yes, 2007. Yeah.
So that is gone.
And then, my lord, as per 2017, they were supposed to find out that whether it was allotted to the Assam rifle or not. But then, my lord, there is a document, my lord. I will just show you that.
See, these are at the border areas. It may not be allotted. They might have taken it over. It cannot be allowed. They wanted a forward base there, so they went there. So show me that you were ousted in that purpose. That's all. There is nothing to show that. And from 55 till 2017, I think, first case.
My lord,
When did you file the first case? 2017.
Yes, my lord.
Then-
No, before, my lord, thing was that villagers, in fact, there was no any record to show that they have filed representation, but then there was
2017, Gita Mehu.
continued communication with the Assam rifle, because they are very powerful, my lord. Even recently, the army has acquired in that Anini area. That area also they have forcefully they have acquired. And then the petitioner, he being educated, he has to file lots of representation. But in our case, even in 1955, the villagers are not aware, and it was not possible that.
Mr. Counsel, if the land of yours were taken away by somebody else, either you were satisfied with that or you were never ousted. You were never there. You may have come into that area subsequently. Now you cannot. You have not even made a prayer for claiming rental at that point of time.
No, that.
Even in 2011, that projection that was
Well,
made.
in the writ petition, Malad, we have mentioned that the villagers being not aware of the situation, they were only expectation of the compensation from the villagers. That's what we have also made a bargain in the writ petition, Malad, saying that they are being illiterate.
Earlier, same land was taken by the Assam Rifles in the year 1955 from the villagers with a promise that they will be compensated. So 55 onwards, you were not compensated. What were you doing? In 2013, after the 2013 Act, you became active. Why?
Because some of the villages, they're aware and they are.
Disputed questions, we can't go into. We can't go into. And those people are also not before us. We'll not go into. You think over what to do. Come back after some time, because if I have to go, I'll go.
Let
all
Malad,
out.
give some time, Malad.
No time.
Because
No time. 19 matter, no time. Nothing can be done here. You will bring them as interveners now. How can they accept their right as an intervener? They can only support you. But here is a question that their land was also gone. They are not made any claim. Who is Gita Miu to make a claim on behalf of unknown villages? 55 onwards. They'll have to establish how they are there.
that's why we have annexed a few of the census, Malad.
A few census will not do. Gita Miu, okay, fine. What about the rest? And Gita Miu does not claim the land to be her ancestral land. It is community land.
Yes. Malad.
Then
No, we have seen in community land being.
you think over it. Come back after some time when you're ready with the answer. We will. If you want me to pass an order, I'll pass an order. But it will be against you. Think over it.
Then Malad, give some time.
No time.
To.
I gave you time enough. No time.
I mean,
Judicial
Malad,
time is very costly.
Malad, in fact, your lordship has asked you the link of the petition, Malad. We are also seeking a document.
You 1955 document you don't seek in 2024. You should have sought it in 2017. And 2017, this court had not concluded anything. It had left everything to the authorities.
But Malad, question here also that land.
Mr. Counsel, think over it. Come back. after some time, say 1 hour or so, give it a think. If you want to withdraw, I'll permit you to withdraw with liberty to do anything, but not in this form. I'm not going to accept it.
Okay.
Madam, after some time,
Yes.
let him think over it. After some time, huh?
May I know?
Hmm.
Criminal petition currently filed by the complainant and the accused person on the ground of mutual settlement.
Yes, madam.
354 is there also.
In the facts involved.
In this case, Lordship, this case was already settled between the complainant and the accused person. And on 14th September, it was supposed to be settled on at the Lok Adalat. But as
Yes,
per the-
madam. Young boys,
Yes, they are
something went wrong
Yeah.
because something was inside them. It is that inside thing that had led
Yes,
to
there,
the-
Lordship, here I can find this lady, Lordship, her name is also there in settlement, Lordship.
Huh?
This victim, Lordship, lady victim, her name is also there in settlement, page 56.
Page?
56.
only complainant
Miss,
victim.
she actually, the incident started from her, but
Yes,
she
Lord.
was not involved in the whole thing.
No, Lordship, her name is there, Lordship, because incident started from her. The 354 is Lordship fame because of
That
her
lady.
Lordship, yes,
only.
Lordship.
Three 354A, clause 1.
I think. Washed.
Obliged.
Disposal. Simple matter.
My please, Lordship.
Yes,
My lord,
you are named. What is this squashing required?
no, my lord,
The
your-
charge sheet brings on record during investigation, you were the main man.
no, your Lordship will just, my lord, I'll take 2 minutes only, Lordship. The conclusion of the charge sheet is something different, Lordship, it's page 69, my lord. This is the conclusion of the IO, Lordship. Last third paragraph, from thorough investigation. Lordship, please.
That
Yes.
material is there. How you had come in the preceding pages.
No, that's why I'm submitting, madam.
Hmm.
This is the conclusion of the IO in the charge sheet alone, madam. Now, in the entire charge sheet, only statement has been made by one of the witnesses, my lordship will find.
See, he has categorically in the affidavit, the charge sheet,
Yes.
said that during investigation, when they revealed that one so and
No,
so
no,
was directed by Tawang Wangham
that's why,
to extort an amount of rupees 4 crores.
yes,
And thereafter, who is the prime accused and is evading arrest.
no, lordship,
Uh,
but I would like to submit this, my lord. In the charge sheet, though the IO
see,
has said.
for the time being, this has to be taken as true.
No,
You have a
that's
chance
why-
in the trial.
That's all. Just if you lordship allows me
Mm.
1 minute only. Lordship, I admit to the legal position, madam, that in the madam, during the investigation, if something is there, madam, then definitely, madam, the court trial can go on. Now, lordship, the only statement, lordship, kindly, madam, page 80, madam, this is the only statement in
80.
the entire charge sheet.
Page 80.
Page 80, madam, 80. This is the only witness, my lord, who has indicted the present applicant. Here, the only allegation is, my lord, when he called the present applicant, and when he called the applicant in the phone, he said, look after them properly, my lord.
Properly, UGC.
My lord, how it can be an offense, my lord?
Be
if
that as
someone
it may,
calls-
that may be an inference drawn by the.
Lordship is aware in criminal, my lord. If someone calls me and says,
Yes, madam.
UGs are there, my lord, I will say, look after them properly, then how I can be, my lord,
Lordship,
made as an accused person?
Lordship, here Lordship, this is the Lordship, they are questioning for the FIR Lordship or the trial Lordship, because,
No.
because
Trial
charge
has-
sheet is there, whether it
Already.
is submitted or not Lordship,
Trial
they
has
doesn't
not-
know.
Charge sheet. is
Submitted.
Yes, we have
Charge sheet submitted.
categorically stated. That's annexed also.
And also, Lordship,
So you are not challenged the charge sheet.
My lord,
The charge sheet is not under challenge here. Only the police case. Police case has now converted into a charge sheet. That is lost its significance. You come to your prayer. She is rightly pointed out.
my lord, if the FIR goes, my lord, even charge sheet also would go, my lord, in my humble
No,
understanding.
there are materials now, sir. We'll have to consider that also.
Only that's the only one statement, Lordship,
Forget
which
it.
I've shown. Otherwise, there's nothing in the entire charge sheet.
I'm not convinced.
Statement under 160.
I'm not convinced. I think I'm the court here quashing much. They are very angry with me these days.
No.
And I'm quashing everything. But these matters I can't. Nothing is here.
My lord, that is the only statement, my lord. My lord, if we
Not convinced.
believe that, my lord, the entire statement
Mr. Tafo,
as a, my lord,
You don't have a prayer also. I can't go
Gospel
here.
truth.
In your this thing, I can't even go into that. Your charge sheet, that is not under challenge. That has to be technically under challenge.
technical debate, then I may be allowed to withdraw, my lord, file afresh.
Mr. Tafo, Learned Counsel for the petitioner. And heard Mr. Tafo, that's so and so, Learned Counsel for the petitioner and Ms. Hage, L. Hage, Learned Additional Public Prosecutor. So, Mr. Tafo has submitted that a technical error had occasion in filing the present criminal petition inasmuch as the charge sheet which has already been filed in the matter has not been put to challenge the proceedings. So he accordingly prays that he be permitted to withdraw the present criminal petition with liberty to file a proper petition ipso permitting the petitioner to file a proper criminal petition ipso advice. So the same is not objected to by Ms. L. Hage, Learned Counsel for the Learned Additional Public Prosecutor. Accordingly, in view of the above, the criminal petition stands dismissed with liberty as prayed for.
Obliged.
Yes.
Yes, Lordship, this is case of the wielding of the one department. And thereby its employee transferred into another department, Lordship. Lordship, may I come to the
First,
first?
you show me what you started off with.
Yes, Lordship. The-
Just establish
Yes.
that department was closed down and then redeployment occasion.
Yes,
Just
Lordship.
show me that.
Yes, Lordship. Lordship, page number 38 is proposal for the amalgamation. Lordship,
38. Proposal, you forget, decision is there at 46.
yes, Lordship, that amalgamation, this Lordship term amalgamation, this is process of the two organizations come together and form the new entity,
Mr.
Lordship.
Counsel, I would have understood if the one organization is closed,
Yes, Lordship.
the employees are held to be excess surplus employees,
Thank you.
and then they are redeployed.
Yes.
Then whatever you say will come in. Here, it's amalgamating with the post. So the man will carry his seniority, and that is exactly what is
No,
being
Lord-
held by the government.
Yes,
And you
Lordship.
have not put that to challenge.
No, Lordship, that determination of the seniority, that this is rule passed by the central government, Lordship. I have Lordship.
Forget central government rule. What did the state government? This is the state government department.
Lordship, and again, there is a Supreme Court ruling also that first service, determination of the seniority, the first service rendered by an employee in its previous department will not be counted, Lordship.
Show me.
Lordship. Lordship, here is one judgment that Lordship, page number 2, that Yogendra Prasad Mandan versus State of Bihar and Lordship and others, Lordship. Page number 2, Lordship. This is
That is what exactly I said. You read paragraph 1, the
Yes, Lord.
last 2 lines, 3 lines, or the last line, please. Paragraph 1, last line.
Lordship. Lordship, in this judgment, that
See, Mr. Here and a substantial staff working at Palampo became surplus. Now, for accommodating this surplus people, there was a decision taken.
yes, Lordship.
And accordingly, they were redeployed. Here, that is not the case. These two departments were the one. Then it got segregated. Long back. Now, again, it has been amalgamated.
Yes, Lordship.
So once it is amalgamated, the condition is that persons will carry their seniority from the date of their promotion in the post. They have come with their post. The departments were amalgamated.
And Lordship,
It's not a question of something being, what do you call that, wound up, declared lockdown, declared surplus, then redeployment taking place. That is
no,
not the
Lordship,
case.
no, Lordship, this is as a winding up of the one department, Lordship. Lordship, may I come to the list? Lordship, impugn notification of the amalgamation, Lordship.
6-2,
For
page
46, page,
46.
page 46, Lordship.
Huh?
Yes, Lordship.
You come,
The,
read the first paragraph.
the Lordship, from the 2-1, I will read.
No, you
Lordship.
read the first paragraph.
Yeah, Lordship, okay. In term of the cabinet meeting held and so, and as approved wide agenda item number 1.
9.
9. In the interest of public service, the Governor of Arunachal Pradesh is pleased to amalgamation merger of the Director of Supply and Transport Arunachal Pradesh with Director of Food and Civil Supply under the Department of Food and Civil Supply.
So what is the thing?
Yes, Lordship.
Amalgamation merger.
Yes, Lordship.
So this is not
Lordship,
winding.
yeah, Lordship, had it been amalgamation, the director would join into the DFCF. Director that transferred into the.
Say that there is a reason for that. He is an APSC officer. So he has been reverted to the personnel department because the personnel department controls them.
Lordship, under the amalgamation
You are
also.
before a wrong
Lordship,
court.
just Lordship, under amalgamation also, there is type of the amalgamation. Absorption
Okay, make
also.
your submissions.
Lordship, as per the amalgamation, this means two departments come together and form new entity, Lordship. In this case, only bilateral act, Lordship. Only one department merge into the another, Lordship. This is not the case. Two departments merge together.
That is for the government to decide how they do it.
Yeah,
We are only concerned whether that organization along with its posts were done away with and people were brought and appointed in posts which were available in the amalgamated
Lordship,
department,
on
which
that-
is not.
Lordship, on that case, the employee who has been transferred into the another, determination of the seniority will not count from the joining of the Lordship, a new department, Lordship. This is the case, Lordship.
Here, that cannot be because
Lordship, there will be variety of the salary, in fact, but counting
we are concerned with the post of office superintendent, right?
yes, Lordship, exactly. And
The
Lordship,
other person was promoted in 2002, you were promoted in 2004. And you have not averred anywhere that the person while being posted to your directorate had joined against a post which was vacant in your directorate. That is not the case.
no, Lordship, I have already mentioned that they joined
Show me.
2017, Lordship.
Show me that he joined against a post, vacant post in your organization.
Lordship, Lordship, page number 20 that I have mentioned that after the winding closure of the DST, private respondent redeployed and observed into GFC on 1.
No, I want a step further. That he was absorbed against a post
Yes,
that
Lordship.
was already lying vacant in DFSC.
Yes, Lordship, I have made amendment also.
Where?
Yes,
Where?
Lordship, yes.
I missed it. Show me. I'll change my view.
Lordship, that is the petitioner also stated that as per the
Where?
Lordship, page number 18, Lordship.
Page number 8.
Yes, this is synonym
Okay.
this amendment.
Okay.
That the petitioner also stated as per the number of the posts in existing office superintendent under DFC, the assistant director and The assistant director, the promotional post has been created as per the RR of the GFC, but without enhancing the number of the posts.
That is your grievance.
Yes, Lordship, exactly.
That is your grievance. But where is the pleading that OS post that the petitioner was, that the respondent was holding in the earlier establishment
Yes, Lordship.
was not the one he continued to hold when he came to DFSC?
No, Lordship, this language.
This is promotional, naturally.
No,
Now
Lordship,
the post of assistant director, he'll have a better claim because he's seniority. But where is the other part?
no, Lordship, under the DST, there is no any promotional avenue. That as per
Forget it, he is getting it now. You just show me that this post of OS he is holding today after
Yes,
2017 is not the post he carried from the earlier department
Yes, Lordship.
or the directorate, but one which is there in your organization. Just show me that this is motion.
Yes, Lordship, motion.
I'll stay.
No, Lordship, this language, it's a deliberation of the language itself. Lordship,
This
here
language is different.
Lordship, here I mean.
I don't know much English, but this is different.
Lordship, that they had no any promotional avenue. And now coming
Mr.
into my,
Promotional avenue will come later. We are now in the entry stage only. You satisfy the entry stage first, then promotional.
no, Lordship, that taking the my position.
Have you got,
seniority
do you
position-
understand
Yes,
what
Lordship, I got it.
then?
Lordship,
We are only with OS. We don't know what is going to happen tomorrow.
Lordship, now I am the senior most. Then why coming into the
That is your grievance. But whether that is only a chance of promotion. Chance of promotion, you have no right. Loss of chance of promotion is not a justiciable thing. You get my point? Consideration for promotion is yes. That is a fundamental right.
Yes,
And you will be considered. Yes, Mr. Ratan. Anything more?
No, my lord. In fact, I was telling him that this is a misconceived petition, my lord. Absorption is totally different. Merger and amalgamation, my lord, is different.
Surplus, deployment,
Yes.
it has a different connotation.
Yes.
Mr.
Lordship,
Counsel, I'm sorry.
Lordship, on that case, Lordship, in fact, there is a prima facie in hand of the petitioner that on that case, by withdrawing this case, Lordship, we will make that point, Lordship. Because
How
this
long
is-
have you been in practice?
Lordship,
How long have you been in practice?
Lordship, in High Court, I am for 6 years, Lordship.
Okay, we'll permit your prayer. If it was 10 years, I would not have permitted.
Lordship,
Mr.
Ji Kata, Lordship.
G. Kato, Learned Counsel for the petition. For the petitioner, also heard Mr. N. Ratan, Learned Counsel appearing, Learned Additional Advocate General appearing for the state respondents. So, Mr. Kato, after arguing the matter at some length, on a query made by this court as regards the nature of the, as regards the manner in which the respondent respondents had come to hold posts in the amalgamated establishment of the Director of Food and Civil Supplies, right?
Yes, Lordship.
Mr. Kato has submitted that the same would require. No, like, continue. Mr. Kato, after arguing the matter at some length, has submitted that he be permitted to withdraw the present writ petition with liberty to approach the respondent authorities, raising his grievances in the matter. Full stop. The above prayer is not objected to by Mr. N. Ratan, full stop. In view of the above, without expressing any opinion on the merit of the issues arising in the present proceedings, the present writ petition is allowed to be withdrawn with liberty as prayed for. All right.
All right, Lordship.
Second number 5.
May I please, your lordship?
Already appointed.
Yes, my lord.
Tack
Otherwise,
for.
yes, my lord. My lord will see, my lord,
We'll issue a notice.
lordship.
We'll issue a notice. Today I can't do anything.
Lordship, but otherwise, my lord, I can show from the records that,
Even if you show that person has been appointed, how
yes,
can I state today?
yes, my lord. But it's been only a month, lordship.
Be that as it may, one day also. Your thing is you got a silver medal and
Yes,
he is only a cadet.
yes.
We'll see. Let them get your instruction. You take
It,
Dusty
this
service.
is, no, this is not what I'm saying. This is as per the records.
I've seen it. I've seen it.
Yes.
But ma'am, they have, that's why I asked you whether they have joined. Once they have joined, we should give them an opportunity of hearing before we interview. That's my view.
Yes, of course,
Okay.
Lordship. In that case, Lordship,
You take Dusty.
yes, a short date. may be had.
I'll have it in January.
Yes, Lordship.
Heard Mr. N. Rangan, Learned Counsel for the petitioner. Also heard Mr. N. Ratan, Learned Edition.
Miss Lordship.
Petitioner. Huh?
Miss.
Miss, sorry. Sorry. N. Ratan, Learned Additional Advocate General appearing for the
Respondent 1 to 4.
1 to 4. State respondents 1 to 4. Full stop. Issue notice returnable on let us have try it on 10th.
Lordship.
10th. Mr. Ratan? Yes, 10th. On 10/1/2024. So, Mr. Ratan, accept. Mr. Ratan, who is assisting you in this matter?
My lord.
Just give me a name.
T. Wangmo.
T. Wamu, Learned Government Advocate, assisting Mr. N. Ratan, accepts notice on behalf of respondents number 1, 2, 3, and 4. No formal notice is to be issued. However, the Learned Counsel for the petitioner shall furnish extra copies of the petition to the Learned Government Advocate within 2 working days. Full stop. Petitioner to take steps for service of notice upon the respondent number 5 and 6 by way of registered post with AD as well as by way of Dusty routed through the registry of this court. Full stop. On effecting service by Dusty mode, petitioner shall file an affidavit to that effect. Full stop. Mr. Ratan, on the next date of listing, shall receive his instructions with regard to the contentions raised by the petitioner in the present proceedings while presenting a challenge to the selection and appointment of the respondent number 5 and 6 against the
5,
post-
Lordship.
5 against the post in question. Full stop. Registry to list this matter again on 18th day.
Obliged.
Just get the instruction. These matters, why keep it pending? That
Yes,
man will work for 5 years.
Yes,
If she has a case, that will go in that only. Yes.
Made reservations.
Mr. Any work order issued here?
I'm not sure, my lord, but my lord,
What order is
prima facie this person has not even submitted the correct bid, my lord.
My lord, this morning only I received this petition. So let this matter be fixed tomorrow. I'll take instruction.
Work order issue, my lord may protect me, my lord. This
Is the work order issued?
I have no idea. This morning only I received it.
You get your instruction if a work order has been issued.
Yeah, tomorrow.
We'll have it after some time. You just get your only that work order. I'll adjourn it, don't worry.
Okay.
But get me that instruction whether the work order has been issued.
My lord.
What is the completion time?
I will
18
check,
months.
I will check.
18 months.
18 months. Get it?
Otherwise, each and every certificate, my lord.
That's your contention.
I have annexed
B 2, 3, 4.
all, my lord. All the bid documents either pertain to some other.
4.4 B 2, 3 B1 B C1 4.4 C.
That is ours,
This-
my lord.
This is what?
That is ours.
Oh, there's
That we have submitted. Theirs, my lord, is a long list
okay.
from page 14.
We'll see. Just get that instruction. Yes, somebody working?
Yes, your lord. It is not that 2 persons are working with unskilled conditions.
Unskilled, not the person who was selected in that selection process. Other than that. Okay. Yes,
Malad, I have an instruction, Malad, written inside of it. Malad, that 2%, Malad, the petitioner was appointed under ISSA as well as SSA, Malad. Now, this 2%, Malad, subsequently appointed under the state contingency fund, Malad, not under ISSA. ISSA is a central sponsored, Malad.
these are just ways of projecting it. Madam, these are just ways of projecting it. Why? A poor man working from 2005. Huh? Why?
Malad,
Not called for. not called for. If you have continuing people other than
My lord.
these are all appointees after him.
My lord,
They are doing maybe under two different heads of pay, but they are doing the same work
my lord.
under the same office, district project officer.
Only funding, my lord.
Funding, forget it. That is your headache, how you fund it. Why? First come, last go.
My lord.
Last come, first go.
That's-
Why do you reverse it?
My lord, that is that part. My lord, in that case, my lord, this two persons required to be impleted, my lord. If anything happens.
You do whatever you want. We'll only remand back the matter to you. You get her back in service.
My lord.
When were you terminated?
2021, 19/7/2021. It's,
This is the first time you're coming thereafter.
yes.
Madam, what were you doing for 3 years?
So I filed this repetition as soon as I was terminated.
20, this is of 21,
Yes.
okay. Then
My lord,
we'll not give her any pay for this period.
my
But
lord,
you
that's right.
take her back. Take her back. But madam, huh? And Mr. T. Dagun, learned counsel appearing for the respondents. Also, the present proceeding has been instituted, presenting a challenge by the petitioner, presenting a challenge to an order dated 19/7/2021 issued by the Deputy Director of School Education, cum District Project Officer, bracketed ISSE, Lower Siang District, Likabali, by which the services of the petitioner as an unskilled contingency peon was discontinued with full stop on the ground of non-availability of fund and non-allocation of separate fund against the post from the state office. You have a post also for that. How can you have a
My lord,
post?
that is my lord, the instruction. I sought for further instruction, my lord. They say that this post, two post, my lord, it was created subsequently after the discontinuation because the petitioner was appointed under
No.
SSA, my lord.
No, forget it.
ISSA.
Wherever you do it, will not enter in this. Lekha. The petitioner hearing was initially engaged as an unskilled contingency for a period of 6 months at a fixed pay of ₹1,000 and was attached to the BRC means
Block Resource Center.
Block Resource Center, Nari. So the petitioner continued to discharge his duties,
Clustered, my lord.
As per the directions issued by the authorities. Full stop. It is seen that in the year 2020, a process of recruitment, again on ad hoc basis for a period of 6 months, was undertaken by the Deputy Commissioner, Lower Siang District, Likabali, against 4 posts of peon and 1 post of driver in the establishment of the Deputy Director of School Education, cum District Project Officer, Lower Siang District. Persons came to be recruited against the said post and came to be recruited in the said recruitment process, and they were appointed in service for a period of 6 months. But however, they have been continued in their respective engagements. Full stop. Thus, the petitioner herein, while the said order dated 19/7/2021 came to be discontinued from his service as an unskilled contingency peon due to non-availability of fund and non-allocation of separate fund against the post from the state office. Being agreed, the present proceedings have been instituted. So, at the outset, during the hearing of the matter, the learned counsel for the petitioner has submitted that persons recruited as unskilled contingency workers after her initial engagement have been allowed to continue in their services, whereas the petitioner was picked up for differential treatment and the order dated 19/7/2021 came to be issued in his case, discontinuing him from his services. Also, thus, this court had required Mr. Tagun to receive instructions as to whether there are persons who were recruited after the recruitment of the petitioner hearing in the year 2015, as unskilled contingency workers and who have been permitted to continue in their services while the services petitioner was discontinued from his service. Also, Mr. on instructions have submitted that yes, that there are two persons who have been appointed sometime in the year 2022, 2021 and 2022 as unskilled workers and who have been permitted to 2021 likha khali. Who has been one person likha, who has been engaged as unskilled contingency worker and who is being continued to serve in his who has been allowed to continue in his such engagement. Also, in view of the above position, the stand of the respondents that the services of the petitioner was required to be discontinued on account of there being non-availability of fund cannot be countenanced, and accordingly, the order dated 19/7/2021 would call for an interference. Also, the petitioner who has been serving in the organization since 18/4/2005 could not have been so dealt with as has now been dealt with by the respondents while the order dated 19/7/2021, and in the event there was a constraint of funds, the principle of first come, last go ought to have been followed. Also, in view of the above position, without interfering with the appointment so made in respect of the others who are not party respondents before this court, this writ petition, the order dated 19/7/2021 is interfered with, and the respondents are directed to reinstate the petitioner in his such contingency engagement as before. Also, however, the petitioner shall not be entitled to any salaries from any wages from 19/7/2021 till the date of disposal of the present writ petition. Also, consequential orders as may be called for in the matter, including the place of posting of the petitioner, be issued by the, who will issue this? Deputy Commissioner. By the Deputy Commissioner, by the Deputy Commissioner, Lower Siwang District, Likabali, and the Deputy Director of School Education, District, what is it called?
District Project Officer.
Within a period of 15 days from the date of receipt of a certified copy of this order. You'll not get anything this period, but I'm asked you to.
Clear.
Yes, Mr. Bami. How do you sustain this after the appeal, after the 2021 Act? File an appeal.
That way, only legal issue, one legal issue.
No legal issue. The wording is very wide here. In 15, sub third proviso.
15, my lord. I find there's ambiguity, my lord. My lord, kindly have a look at my lord. I have submit one, my lord. This is amendment 210.
When is the decision of your that inter-village community, inter-village court? When it is?
It is page number, my lord. 41, my lord. Index number 4, my lord. Date, my lord.
This is the third parwana.
23/7, my lord. 23/7, page number 41, my lord.
23/7?
My lord.
Date 23/7?
Type out, my lord, you will find it page number 43, my lord.
43.
Date is mentioned at second para, my lord.
So this act has undergone an amendment.
Amendment.
This amendment is of 2022. And
20.
therein, the inter-village territorial customer has been recognized.
Recognized, my lord. At that time, my lord, only legal issue, my lord. Here is, my lord, simple, my lord, I'm putting a simple consideration, my lord, is whether inter-customary court, my lord, has original jurisdiction or appellate jurisdiction.
Why
That
should
does
we
it.
go into that?
That is, my lord,
Both have been now,
no, if, that's why, my lord, if I.
okay, you mean to say that now only an appeal can lie
My lord.
from the village authority? Who is appearing for the private respondent?
Your Lordship.
Yes.
Your Lordship, as per my understanding is concerned, he has to go to senior division civil
No.
court for appeal.
No. If you come to the amendment
Yes.
to subsection 3 of section 15,
Yes.
this, and you also admit this is not the village authority, this is a intra-village authority.
Yes, Your Lordship, since the subject matter is cannot be taken up in a
Why?
village
Why?
level
Why?
because the land of the in question is located in the in the circle level where inter-village customary apex court has
Is
to
it
be
not
carried.
within one village?
No, it affects
encompass
entire village.
2-3 villages,
Yes.
2 villages.
Yes,
me
exactly. That was.
Show me that.
It's Your Lordship.
That this is not covered by one village authority, but it comes within the jurisdiction of more than one village authority. Just show me that.
Your Lordship, the land is located in the circle, in the Sago circle where the meeting was presided.
Circle is a bigger concept.
Yes.
Where is exactly which village the land is concerned?
It's Isisiku village.
Is it that land belongs to Isisuku village?
Yes.
Right?
Yes.
Within Isisuku village.
Yes.
Then why will the the village authority of that village not consider that?
In that case, Your Lordship, it may be reverted back to the.
I'll interfere with this.
Your Lordship, there was 3 Puranas. One Puranas was issued in
Forget
the
Parvanas, when the authorities, when they don't have they have an appellate authority, not an original jurisdiction. And you say that the land falls within Ishi village.
Yes.
The village authority shall consider. Yes.
Your Lordship, this
Mr.
original jurisdiction has to be
Clarified.
clarified.
What is the position now, legal position after the second amendment?
Up to the second amendment, first it has to be.
The village by village authority.
Then any of the party agree.
Can go, by agreement can go before a intra-village authority. A inter-village authority cannot have the original jurisdiction.
Original.
Sure.
That will be in the form of appeal only.
We'll interfere with that. We'll
Yes.
remand you back to the, which village authority?
Ichisiku, Your Lordship.
Isisiku, my lord.
Spelling? Where I get it? Where do I get it?
It's in,
Ishichiku.
yes,
ESHI-CHIKU.
yes.
You have a village authority for this village also? Mr. Council, you have a village authority for this council also?
Yes, Your Lordship.
Village
We
also?
must- Yes, every village has a head gaon pura, Your Lordship.
Village.
Your Lordship, I have no objection since this is a matter say which needs decision because
There is no decision required.
Yes.
We will.
original jurisdiction determination of original jurisdiction whether the inter-village or apex court can play the original jurisdiction or the village level can play the.
I don't think so. This is a case for that. We'll decide it in a
Yes.
appropriate case.
Your Lordship.
Okay. Heard Mr. L. Prami, Lanka Council 40. We are disposing it of. We are interfering with that. And we are remanding back you to the village authority.
Yes.
Both of you appear. L. Prami, Lanka Council 40 petition. Also heard
R. Raksa.
R. Raksam, Lanka Council 40. All the respondents.
Yes, for all the rest.
For all the respondents. So the challenge in the present proceedings is to a decision dated 23/7/2023 taken by the, what is that body called? By the what is that body called?
Inter-village.
Inter-village traditional customary apex court.
Inter-village traditional customary apex court on 23/7 likhishuna so and so deciding a dispute pertaining to a plot of land by and between the petitioners and the respondents herein. Full stop. The short question arising in the present proceeding is as to whether the inter-village territorial customary court, which had decided the issue, would have an original jurisdiction in the matter and or can only have a appellate jurisdiction after the issue was so decided by the jurisdictional village authority. So, Mr. Pame has placed reliance on the provisions of the Arunachal Pradesh Civil Code Act 2021, more particularly Section 15 thereof, and has submitted that the provisions of Section 15, more particularly subsection 3 thereof, had undergone an amendment. Full stop. An amendment in 2022, and the inter-village territorial customary court was, or apex customary court by whatever name called, was denoted as an appellate forum from the decision of the village authority, if agreed to by the parties. Also, the rules of the provisions the provisions of the fourth proviso to subsection 3 of section 15 as brought into force by the Arunachal Pradesh Civil Codes Amendment Act 2022 being relevant is extracted here in below. 3, page A to A. Full stop. A perusal of the provisions of the fourth proviso to subsection 3 of section 15 reveals that the inter-village territorial customary court or apex customary court by whatever name called, shall have the appellate jurisdiction over a village decision of a village authority, provided the parties by agreement submit to such appellate jurisdiction. Full stop. The provisions, said provisions would go to also reveal that the inter-village territorial customary court in an issue arising in the present proceedings would not have an original jurisdiction. Full stop. It has been, the parties have arrived at agreement that the land which is in dispute falls within
Sago
E-
village,
huh?
Sago village,
falls within
Sago village.
what is this Ishichiku then?
Sago is a circle actually.
Sago is circle, Ishichiki is, it falls within the Ishichiku village.
The
Is it falls, does it fall between two or more villages?
No, this petitioner responded as of Sago, my lord, land falls under also Sago, my lord. Now, ECC, whenever my lord, inter-village is meeting is called, my lord, ECC is.
Where is this land? Which village this land falls under?
The Sago village, my lord.
Sago village.
I have categorical statement.
So, okay, falls within the jurisdiction of the Sago village. Full stop. Accordingly, the decision not having been in the first instance arrived at by the village authorities of Sago village, the decision so arrived at by the inter-village traditional customary apex court on 23/7/2023 would be in violation of the provisions of a violation of the fourth proviso to subsection 3 of section 15 of the said Act of 2021 bracketed as amended. Full stop. In view of the above position, the decision of the inter-village traditional apex customary apex court dated 23/7/2023 stands set aside. Full stop. The parties are now directed to approach the village authority of Sago village for resolution of their disputes. Full stop. Such approach shall be made by either of the parties within a period of 15 days from today.
1 month.
1 month from today. Full stop. Thereafter, the village authority shall issue notices to both the parties and thereafter proceed to consider the dispute and pronounce its decision in the matter. With the above observations and directions, the writ petition stands disposed of.
Oblige.
So, my lord, I am admitting the, but then making some few points.
Just keep it there.
Against two check, legal notice were issued on time, but then filing of the complaint was beyond the time prescribed. So there is a delay of 26 days. As far as
Just show me the NI Act, Negotiable Instruments Act. यहाँ पे नहीं होगा शायद, बहुत सारे। So there was a 26 days delay in instituting the proceedings.
in two checks, there are delay of 26 days.
Both the checks are involved in one proceeding or two proceedings, sir?
Well, or there are 5 checks involved in one proceeding.
One proceeding.
Proceeding. It should have been in separate proceeding.
Separate.
And then, my lord, although they have submitted their statement in affidavit form, but then that is not a substitution for the requirement that section 200 for the magistrate to at least record his satisfaction. No, only one thing is, my lord, here. The second one, the second issue. In paragraph 6, they have mentioned about the issuance of legal notice, but they have not mentioned whether when they have received it and or whether they have replied or not. So, without counting any date when when the legal notice was received, without taking into account, there is a
138C requires 15 days.
Yes. 15 days plus 15 days is
provided nothing contained in this section shall apply unless the drawer of the check fails to make payment of the said amount to the payee or as the case may be to the holder in due course of the check within 15 days from the date of receipt of the said notice. And 142, such complaint is made within 1 month of the date on which the cause of action arises under clause C of the proviso to section 138. So 138C says 15 days from the date of receipt of the notice and another 15 days, 1 month from the date.
My understanding is because when we serve legal notice, we always
there is a provision for condonation also here.
Yes, madam.
Why have you not filed an application for that effect?
In my brief, I have indicated that. Last line, the complaint can be filed again seeking condonation of delay.
Can a second complaint be maintainable?
And then there has to be actually separate cases.
Five. He's a second complaint made him on the same cause of action.
Oh, no, my lord. This is the first one. This is the first instance because the check bounced and they ought to have filed it within the stipulated time. They have not. In the first case, there is a delay of 26 days. And the second case, there is a delay of 6 days. That is also my lord, without divulging when they have received the legal notice. If it is shown that the legal notice was received after 7 days or 6 days, then there is no delay. Anyway, my lord, this since it is not very clear, my instruction is that this may be remanded back, and then we will attend to all these issues in the lower court as deemed fit and proper as per law.
You are the drawer of the check.
Yes. Now the in 138 the proceedings, my lord, at times the conduct of the persons are also important, because in my complaints I have annexed all those our correspondence through WhatsApp and his request not to press for the payment and assurance that he is making arrangement for the fund. But later on in his
But see, you have created the mess by amalgamating all the 5 checks in one process.
it was a wrong steps.
Now tell me, if I have to interfere with this order,
Only my lord,
but there
liberty
are 5
to
checks involved.
only to some kind of an indication of liberty to approach the court as per provisions of law, and that includes filing of condemnation petition. And then, my lord, all this whatever had happened, this is and this will always be the honorable judge will definitely consider that this delay till today was caused due to pendency of
No, that
cases.
would have been
Yes.
that would have
But
been
then-
permissible, but now the cognizance has been taken, not taken.
Not taken, my lord, not
Cognizance has been taken, your lordship.
It's been
Cognizance
taken.
has been taken, your
Cognizance has
lordship.
been taken.
they, my lord, my submission is recording the statement under 200, section 200 is compulsory, mandatory. It has to filing
But
of statement by.
you were not present on that day. This is the last date, 1/5/2019. Thereafter, what happened?
No,
After
thereafter-
1/5/2019, what has happened in the proceedings down below?
In that case, your lordship, they have not appeared, not have given their statement before the learned trial court.
When was the last day? When is the next date fixed?
At presently, your lordship, the next date of the aforesaid case is probably in the next month.
January.
And the proceeding has been stayed by the order of this honorable court.
There is a stay here.
Yeah,
Yes,
yes, your lordship.
Okay.
May I please, your lordship?
When did you receive the notices?
Your lordship, I have not received any notices. The thing is that, your lordship, it was the duty of the complainant in the complaint petition. They should have mentioned that when the notices were received, they have not given any AD card whether I have received it or not. They have not annexed any postal taking report as well, your lordship. And that's what our plea
So
as
you
well. We have taken.
deny acceptance. You deny that the notices were served on you.
Yes, your lordship. Because that
Okay.
has not been served upon us.
What do you say? We do one thing. We interfere with this order. We remand back the matter because cognizance cannot be taken because the statement till now has not been recorded. So we remand back the matter. We permit them to file an application for condonation of delay in terms of the proviso to 142C.
But the thing is that, your lordship, the cognizance already been taken. They should have done prior to taken of cognizance. And moreover,
Where is the
plea?
order taking the cognizance? That's
page
we are
42.
interfering. We are
Yes,
interfering
yes.
with that. Because without recording the statement under he is not a public servant. 200, how can the cognizance be taken? We'll interfere with that.
And my lord,
We are
And your
interfering
honor,
with this order. Mr. Counsel, the cognizance was taken by 1/5/2019.
yes, your lordship.
We are interfering with that. We'll hold it that it could not have been without examination under 200. But we will provide that it will be open for the respondents hearing to invoke 142C proviso to 142C. What do you say on that?
And in that case, Your Honor, if that has been done, even the legal notice had not been sent on that on the limitation period, Your Lordship. That was a prerequisite on Section 138. So
Okay.
my prayer is that, and the 5 checks have been amalgamated and clubbed together and filed in a single petition. And for that, I have a ruling of Honorable Supreme Court as well, Your Lordship.
What is that?
I have 3 rulings regarding of Honorable Supreme Court. First one is Kamlesh Kumar versus State of Beer. This is a judgment passed by the 2-bench judge A.K. Sirian R.K. Ramakrishnan.
What is the citation?
Your Honor, Your Lordship, the thing is that I have downloaded it from the Indian Canon, and from this I have not been able to get the citation number, but I have got the case number. If Your Lordship permit, I can submit the scan copy in the court's email address.
Do that. Give me all the 3. Today.
Yes, sir. Yes, Your Lordship. And the thing in that it has been categorically mentioned by the Honorable Supreme Court.
You just give it. Let me just peruse it. We'll have it. Today is Tuesday. We'll have it on Friday. We'll pass orders on that. Give me your citation.
Yes, Your Lordship.
My tentative view, we interfere with this order because this order, with insofar as cognizance is concerned, is bad. We remand back the matter. Thereafter, you take all your pleas with regard to this amalgamation of checks, this, that, everything there. He will also be permitted to invoke 142C.
Yes, my lord.
But my prayer is that on Friday I may be allowed to submit the judgment, because on this 3 judgment the court categorically held that if the cognizance has not been taken and legal notice are not sent in time, then the court doesn't have power to make any cognizance, and it should be.
See, you take that plea before the learned court because the learned court had not examined those issues. They go back. I'm not passing anything that the court should take cognizance. I am saying that the cognizance that was taken is wrong. I'll interfere with that. You take all these pleas before the learned trial court. What do you say?
But Your Lordship, what my understanding is states that the impugned order 1/5/2019 is totally vague, because moreover no interpretation has been given in the.
I'm interfering with that order. I'm setting it aside. I'm allowing your appeal. Then what? Then what?
Then they might. Yes, Your
Lordship.
Lordship.
To go back, right?
Yes, Your Lordship.
Will go back. Huh?
Yes, Your Lordship.
Let the court take a fresh conclusion. You have everything open. You make your submissions there. This I'm interfering.
Yes, Your Lordship. Yes, Your Lordship. Yes,
Are you agreeable to that?
Yes, Your Lordship.
Then I'm closing it. You give me those citations. I'll put a reference to that also in the order. Today now only you mail it.
As far as this statement that legal notice was not served on them, they have annexed the copy of the legal notice in annexer 4 and 5.
Oh, they have made submissions. Let them make submissions. Mr. Patin, will the submissions change or make your case good or bad?
No, Malad.
I'm not saying there on record. Go and decide.
But then it is
this order we are interfering.
Wrong submission, Malad.
So my prayer is that, Your Honor, the order may interpret, and the impugned order may be set aside, Your Honor. And
I am setting aside the order. I am remanding back the matter to the trial court. I am allowing this criminal petition. Okay.
Oblige Your Lordship.
And Mr. Patin is conceding. What more do you want? You can have a nice laugh now. Have a cup of tea. Relax.
I am submitting the judgment today itself.
Just now. You submit it to the mail. We'll incorporate that, but we'll not render any opinion in the matter. We are only interfering with the orders, remanding it back by consent of parties. Let the trial court decide. And it will be open for both the parties to take steps in accordance with law.
Yes.
And steps and submissions in accordance with law. Okay?
Yes, Your Lordship. Yes, Your Lordship.
Your name is Mr. Brijesh Kumar.
No, Your Lordship, my name is S. Bhattacharjee.
S. Bhattacharjee. Sorry, I think we have recorded your name.
Yes, Your Lordship.
Okay.
Right.
You just give me that decision, so I'll pass the order.
Yes, Your Lordship.
Can you just mail it now only?
Yes, Your Lordship. I'm definitely doing it.
Dispose of.
Oblige your lordship.
Right.
Your Lordship may kindly have page 53.
53. Okay.
The 7-pay commission, my lord, recommendations were accepted in toto, my lord.
Show me that.
That one,
Show me first that NPA recommendation of the.
my lord, we
uh,
kindly have page 53, but this was
right.
adopted.
Hmm.
I will directly come to clause 3, serial number 3, subclause 2.
Hmm.
The NPSL continue to be treated as pay for the purpose of computation of dearness allowance and other allowances, except those allowances in respect of which the applicable orders provide otherwise, including calculation of retirement benefits. So once this is, my lord,
This is by the central government. This is not the original adoption of the
yes,
7 CPC. This is a subsequent adoption.
yes.
You can come to the first paragraph. Is
That I
directed.
understood, my lord.
Then
But how, my lord, only on the because of a fortuitous death of somebody retiring on a particular day, a class can be created, my lord.
it's not being created. What is being
been
created
created,
is that these persons who are there in service
My lord.
are also being granted from a prospective date. They are not being granted from a retrospective date. You are
But-
already getting 25% at the old rate.
All right, my lord.
Ah.
But because of the recommendations of the CPC, the basic pay has grown so much.
I got it, but
Yeah.
here, this power, we'll have to concede to them. And what
My
is
lord, in my
happening
humble
here?
Understanding, my lord, one pay, my lord, pension has to be computed on the basis of the basic pay.
Even
But
even the central government
My lord.
had granted the 7 CPC benefits from 2016, 1/1/2016.
Yes.
NPA, you see, it was not
In-
granted from 1/1/2016.
Yes, it was granted, my lord.
You come,
It was granted.
you come to page 54. It was granted from 1/7/2017.
Yes.
So
One,
it is not something that
But-
this is coterminous with the
Yes, yes,
7
because,
CPC.
because it is in respect of those officers who are, my lord, working. But for those who retired between 1/1/2016, they have also been granted. Where the subsequent memorandum, my lord. At page 55.
with effect from 1/7/2017.
My lord will see page 55.
No, I'm 55 only. Para 3
Yes,
shall be revised with effect from 1/7/2017 by adding.
but this is in
NPA.
respect of those medical officers who retired, died during 1/1/2016 to
16 to 30,
30.
but none of your petitioners here
My lord.
had retired within that period. They had retired subsequently.
What I am submitting, my lord, is.
No, Mr. We'll consider what is there. Let us see your case. I think you have brought on record
Yes,
a
yes.
list. It was here somewhere. You come to
Page 11
page
onwards.
11 onwards.
Yes.
So the first earliest is 2018.
18, yes.
So this will not cover. So here,
My lord,
the
what I am
cutoff date
submitting
is
is,
1/1.
as far as central government is concerned, they issued the office memorandum in 2017. So that is why, my lord, it is for the period 1/1/2006 to 2017, my lord, they have been granted.
But here the state government having specifically said that we will only do it from 1/1/2023.
Yes.
We can't force them.
My lord, in
Or
my
you show
humble
me a law to
submission,
that effect.
if, my lord, NPA is helped with pay, my lord, for consular return benefits, DS Nakara will, my lord, apply in full vigor, my lord.
No, it will not, because what is here is a revision. You have been continued with 25% at the old rate.
I have understood, my lord. What I am submitting is, if this has to be construed as pay, my lord, NPA, but pension has to be determined on the basis of pay.
Allowance is added, it's an allowance.
NPA
Moment it
for-
is granted, it will be added. It's not that there is a vacuum with regard to
That
that.
is why I am submitting, my lord. NPS helped to be part of pay, my lord.
Yes, Mr. Ratan, why have you done this?
My lord,
Because
in our affidavit,
there are other aspects also, my lord.
I'll come back.
we are saying that NPA is not a pay. It's an allowance.
That is
It
the
is
extent.
added to the pay.
Added, my lord. Here, my lord will kindly see page
Your final
46.
pay,
Yes,
now it's matrix. Earlier it was your, what do you call that? Pay would mean pay band,
Yeah.
grade pay,
Great, great.
DA
DA.
and NPA.
NP.
Together, his HRA, all other benefits would now be calculated by amalgamating this as pay.
Yes, my lord.
His case is, why are you depriving us? You show me.
My lord, here at page 46, this is
We're on various other grounds also, my lord. No,
I'm coming back. Let us get it. I'm not closing this, mister. I'll go till the last time I'll give you can convince me. Yes.
page 46, clause 8, my lord.
Because I've seen that.
The decision of the revised rates and the date of effect of all allowances other than the dearness allowances based on the 7th TPC shall be notified subsequently and separately.
What Mr. Punning is trying to project is, once you have accepted the recommendations of this central government with regard to pay commission, 7th pay commission, right?
Yes, madam.
You have accepted everything.
Yes.
So why did you not accept the decision of the central government with regard to NPA?
NPA, the 2017, madam. 2017, madam. That we have not accepted, madam.
Why?
We are going to be enforce it from 1/2000.
Where is your justification in the affidavit? There is nothing.
Madam, this is
There is nothing here.
yes, madam. That is the prerogative of the from which date the
Give me a reason. I'll have to put it in my order. Rejecting Mr. Pani, that this
Yes.
is the say financial hardship.
yes.
Financial hardship. Where?
Madam, we'll see. At page 79, this is how this has been addressed.
You say doctors have to choose. They will choose. They have already chosen. They are getting 25. So there is no point. It's
Yes,
only a revision.
Madam, here the orders, office memorandum.
You don't be happy. I'm not with you. Don't be happy. I'm not with you. I'm only trying to take out things from.
Because it says, although there is not
Page,
much.
Page
79, which says about
2 minutes, Mr. I'm coming back to you. 79. Okay.
this is
the notification.
notification, which says, my lord, when the NPA will be applicable. Madam. Revision of rates of non-practicing allowances in respect of medical
got it.
posts.
That
In the
is
interest
there.
of public service, government is pleased to grant non-practicing allowances to medical posts under Government of Arunachal Pradesh as per revised rate notified by Office Memorandum number so and so by the Department of Expenditure so and so pay with the following terms and conditions. What they have adopted is the 2017 notification of NPA. The health department shall prepare detailed guidelines for implementation of the revised rate of non-practicing practice allowances for medical posts under the Government of Arunachal Pradesh, clearly stipulating the terms and conditions of so and so. Then, serial number 2, the revised rates of non-practicing allowances shall come into force with effect from 1st January 2020.
So this is what is till 2, the 1, no, nothing.
Yes.
Why this is 1/1/23 when you are adopting 7/7/2017? You are adopting literally.
Yes, madam,
why?
this is a decision of the government from where?
Why? I only want that why. Give me a
Madam,
line answer.
maybe because of
Not maybe. Give me that answer.
Madam,
From your affidavit. You go through your affidavit. Yes, Mr. Panu.
we are only saying that it is the prerogative of the government, madam.
It cannot be.
and-
It has to be a reason. Okay, if it's your prerogative, show me that you can, when you are adopting a central government guideline in toto without any reservation.
Madam,
How come?
we have clearly in the first, while adopting the 7th pay commission.
Where?
We have in clause 8 stated the other
That
allowances.
is Government of India's notification,
No,
not
madam,
yours.
our page 46, madam.
46. 46 is your notification.
Yes, madam. 45, it starts from page 45. This is our notification. Here we have said in clause 8,
Yes, clause 8.
we have said that decision of the revised rates and the date of effect of allowances will be
Where
announced
is the
later.
notification adopting this, of the central government adopting the, is it on record? Seven CPC.
Same notification, I believe.
No.
No. Central
Central government, I
government
think, is page 30,
is
29.
page 29.
No, this is the
This
central
one.
government.
Yes, this is the central government.
Because this was adopted by the state government.
Yes,
This was adopted.
in total, my lord, from the same date.
Mr. Panik, come to page 32, B1.
32B, yes. NPA. The B2,
Yes,
my
I've
lord,
seen it.
the pace of fixed under subclause 1 shall be added by a revised, pre-revised non-practicing allowance admissible.
So while adopting, let's say the state of Arunachal Pradesh had adopted this in toto, 25/7/2016 in toto. It was adopted with this condition. Okay. Now the central government, that adoption is at page 45. 46 clause 8, right?
Yes.
So now you satisfy me that they will have to also follow the decision of the committee constituted by the Government of India and the Office Memorandum 77/2017.
But I'm submitting on a totally different line, man. Once NPA has to be constituted as pay, my lord, then my lord, DS Nakara will have to apply, my lord. Because it is India.
Show me which paragraph of DS Nakara.
No, DS Nakara is only on pension, my lord. It is not on NPA.
We are on NPA, date of NPA, cutoff date.
What I am submitting is, my lord, the office memorandum itself says
See,
NPA.
the law is that the cutoff date we cannot prescribe. It's for the government. With regard to
DS
the
Nakara was also on cut-off dates, my lord.
DS Nakara now has been watered down to a
My
great
lord,
extent.
Manipur.
You place that, whatever you want to. Because this much of discretion we'll have to give to them. You can't.
In that
take it.
case, my lord, on NPA, my lord, will give me some more time, my lord.
Tomorrow?
Not tomorrow,
Day
my
after,
lord.
day after.
Day after, I'm not here.
Oh, Monday,
Tuesday, man.
Tuesday. Done. But the Learned Council for the parties at length, hearing remains inconclusive. Registry to list those matters on Tuesday next time as a parted matter.
Because this NPA, my lord, was even by way of an
Mr.
amendment.
You give me a decision.
I'm not only
Yes,
not
my lord.
only on that matter. In fact, my lord, this may be fixed for hearing, my lord. So no, I'm not only on this matter. I'm on various other grounds also.
What other
My lord,
grounds?
the discrimination, my lord, there is on what basis, but they may have that, my lord, discretion, my lord. But there has to be some reason shown, my lord, why, my lord, a person retiring on 31/12/2022 will not get that benefit. And, my lord, the person retiring on 1/1/2023 will get that benefit, my lord.
Unfortunately, I can give you decisions contrary to what you are arguing. Okay, we'll hear it for, then we'll have it for hearing. You have your earth's content.
Yes.
But if it comes back to me, this is my view. Okati. First of all, Mr. D. Panik, Learned Counsel for the petitioner, as well as Mr. M. Ratan, Learned Additional Advocate General, appearing for the state respondent, submit that the matter would require a deeper consideration and accordingly submits that the case be fixed for hearing. Post up. Prayer accepted. A registry to list those matters for hearing. Hearing on in the week commencing from 3/2/2025, right?
What is the item number 6 instruction is covered.
6.
Motion.
Okay. Yes,
Yes, work has been already awarded.
when?
That I asked him to send the record, but still I have not received.
My lord,
Then in that case, let it be taken up tomorrow.
No need. We are fixing. When are you coming back? 16.
yes.
Heard Mr. D. Pani, Learning Council for the petitioner. Also heard Mr. 16.
Ji Tarak.
D. Tarak, Learned Standing Council, Rural Works Development Agency, huh?
Rural Works Department.
Rural Works Department for the respond number 1, 2, 3, 4, 5, 6, 7.
7 years.
Full stop. It has been awarded to respond number 8.
Yes.
Full stop. It has been submitted at the bar that the work order has already been, for the work in question in the present proceeding has already been awarded to the respondent number 8. Full stop. In view of the contentions, categorical averments made by the petitioner in the present proceedings about the bid as submitted by the respondent number 8 and 9 to not conform with the NIT requirements, comma, this court as an interim measure directs that status quo with regard to the work in question shall be maintained as on date. So that is to mean that even if the work order is so issued, the same shall not be implemented till the next date of listing. Registry to list this matter again on 17/12/2024. Full stop. Mr. Pani shall, in addition to the extra copies required to be so served upon Mr. Tarak, shall also serve 2 extra copies upon Mr. Tarak, and Mr. Tarak through the departmental authorities shall ensure that the same are served upon the respondent number 8 and 9 before the next date of listing. Full stop. On the next date of listing, acknowledgements of receipt of notices by the respondent number 8 and 9 shall be placed before this court by Mr. Tarak. Don't file an affidavit. Give me that one. Full stop. Madam, ऊपर में एक ठो खाली लिखना issue notice to the respondent number 8 and 9 by registered post with AD as well as Mr. So-and-so shall serve 2 extra along with that 2 extra copies so-and-so. Full stop. The interim order so passed today shall be further considered upon hearing the learned departmental counsel as well as the counsels for the private respondents on the next date of this.
Yes. Okay.
Okay.
My lord, it was fixed for Burswell. So my senior colleague, he will argue the matter.
Who?
Mr. Sanjay Kumar Setri from Delhi.
Okay. Yes, sir.
Worship. This small controversy which involves the petition is that with respect to the order dated 13/6/21, wherein I say that it is retrospective and I have completed 21 years of my service. Therefore,
But
I
they have modified that order.
I have entitled, yes, my lord. What they had done, Lordship, let us go through the history of the case. What has happened is that, may I, Lordship, Annexure 1, Lordship. I was initially.
Mr. Chepri, we can leave all those.
Yes, my lord.
You were regularized from the month June of 2001. But
Okay.
subsequently, because of audit objections, they have re-modified that order and made it prospective, right?
Lordship, that is the arbitrary action. Let us see the order listed
Okay.
21/13, Lordship.
Have you received a copy of that order, 2017, at any point of time?
No,
during
my
your
lord.
service?
No, my lord.
Where is your statement to that?
Lordship, this is brought to a notice only when I put my request for voluntary retirement. Subsequently, later through WhatsApp, they send this.
So you received that copy before you
annexes.
came?
But, Lordship.
You received that copy before you came to this court?
No, I have received the Annex 6 wherein they said because of so and so reason, we are reckoning a service from 9 years, 1 month, 3 days. In this
I'm not on
letter-
that. I am on the, if you can have their affidavit.
Yes, ma'am.
Page 23.
Lordship, before I proceed, I want just to make one submission. In the reply itself, Lordship, they have categorically admitted the fact that the appointment was retrospective effect. Lordship, kindly have the para 8 of the reply, page 4.
Yes, continue.
Then what remains? Lord? They say that with regard to the statement by the para so and so, as per recommendation of the DPC held on that is so the petitioner was appointed to the post of peon under this department so and so with retrospective effect 13/6/2001. Now here itself they are admitting it in the reply. Then what else remains, Lordship? When they say it's if they have contested or denied it, then they would have in case. Now in reply in para 5 they
Mr.
say.
Counsel, can you just clarify one factor?
Yes, ma'am.
Did you receive this 2017 page 23 notice during the time of your service?
No, my lord.
Where is your statement to that effect in your reply?
That insofar that letter is concerned, what I have stated in my petition is, my lord, that technical problem is there, my lord. But I have stated.
But here, so you cannot rely on that because they have already modified that order. We will go by the modified order. Now, what is your case?
The modified order cannot sustain, my lord. Lordship, for
where is your challenge to that order, Mr. Counsel?
Lordship, then I will request my lord, let me put on additional effort. I will challenge this also in this.
Additional affidavit is not a way out.
Lordship,
You got to find a bypass surgery for this.
Because this is a 226 petition, Lordship has a magnanimous jurisdiction in this petition, Lordship.
Okay, then let me talk to Mr. Apam. Yes, Mr. Apam.
Lordship.
You admit that this man is working from 2001.
He worked not in a substantive post.
Be that as it may, he's working there. He is drawing salaries, wages from you.
Yes.
You're this regularization of 2013.
That's it.
Right? Let us hold it as prospective in nature. We go with your, that it will be only effective from 28/1/2013. But thereafter, he has around 9 years of service.
Yes.
Huh?
Yes.
Why will his service prior to that not be added to this as qualifying service? He'll be entitled to mention.
Lordship.
The period
Lordship.
prior to that is permissible to be added, counted along with the regularized service for determining the qualifying service for pension. He'll have more than 20 years.
Lordship, now the legal proposition will be where
There is a line of Supreme Court judgments on that. That once he is regularized, that period can be added. Finish. That's the end of the matter. Why go for all this things? We make him eligible. We pay.
we have placed it to the pension department.
Forget it.
So-
Forget pension. You have placed a particular proposal. They will only go because they only look this much. They don't look broad.
He was appointed in the higher post. Now he's been
Because of
regularized in
his ailments. And you have done it, not he. You have done it. You have permitted that.
No. We
I
are
don't-
sympathizing him, Lordship.
That's
because-
it. And that
because of his
sympathy, that sympathy, we are taking it a step forward so that this man can sustain.
Can the department rectify its own mistake?
Yes. You
That's
have
why-
rectified it.
Yes, that's why.
You have regularized him. There is no dispute on that. You have regularized him prospectively. So your contention is 9 years, odd months. He'll not be entitled to pension. But that 9 years, along with the period he has rendered from 2001 till 2013 regularization, is to be given to him for calculation of pension.
Lordship, now, in one point of time, he will be driver. In one point of time, he will be.
Treat him as peon. Nothing more. He will not be a driver. On the date you are saying goodbye to him, treat him as a peon. That's all. But give him his pensions.
He's been getting all the salaries, Lordship.
Salary is different thing. Pension is different. That period. Yes, Mr. Counsel, what do you say?
Yes, my lord, I am, because I don't have grievance with the driver peon, I am ready with the peon itself. But since
Show me
this
the
service has to
judgments.
require-
Show me judgments which permit counting of your ad hoc service once you are regularized. Give me those line of judgments.
Lordship, I'll give you, Lordship, I have one judgment with Mr. Deka with regard to interpretation retrospective effect that paraport.
Forget it. We are not going into that. Need
That is
not go
one
into
thing.
that.
That is one
You,
thing.
Mr. Counsel, have you understood my proposition? That
Yes,
the
yes, ma'am.
period you have rendered prior to regularization has to be counted. Give me a judgment to that effect.
Lordship, I'll give you the next date of hearing, Lordship.
Today.
Readily.
No, today. Today.
Yes. Lordship, I'll.
Today. There are enough judgments. You give me, I'll project it in your name.
Lordship,
And I'll pass the order.
Lordship, highly obliged.
At 2 o'clock,
Lordship,
give me those judgments.
Lordship, it is not a case of pension. It's case of voluntary retirement, Lordship.
Accept that. Accept that.
So,
Accept that. If 3 months notice is required, he'll pay you 3 months salary in leave. Give it. Give it. Anything more, sir? Why keep a poor man working for you? He's also not keeping well. Pay.
Chief man.
we have done enough for him, but
A little bit more. And Mr. Apang will use his
That-
good office for that.
Lordship, that will be paid by pension department.
Whoever,
So,
whoever. Whoever is the pension payment authority. It will be paid by the government of Arunachal Pradesh.
they are not party here, Lordship.
Need not be. We will direct you to put up a proposal now. With this, in this manner. We'll have it on Thursday. You get me the judgments.
Highly
Mr.
obliged.
Chetri, you get me the judgments. I'll have it on Thursday.
Highly
There
obliged.
are judgments. Supreme
my
Court.
lord.
That much you got to find out now.
Yes, my lord. I'll always.
30 parties at length. List this matter for further hearing on Thursday.
Highly obliged.
Okay. Mr. Apang, if you can get anything contrary,
Yes,
let
sir.
me know.
Lordship. If need be, Lordship, I'll give in
Please,
writing,
please,
Lordship.
please do so.
Yes, there was call for.
Yes. Anything?
Only 3 transactions, my lord, I can see. One is 10,000, 3,000, 1,000. This will not come under predicate offense, my lord.
This may be the tip of the iceberg.
Lordship, in the statement of the alleged accused Sukhdev Dev, he has
Now it
admitted,
has come.
he has admitted that, Lordship, there's many times his even this court was used, Lordship, and with more than 80,000, Lordship. Regarding Lordship, the custody interrogation, Lordship, detention, Lordship, because the recovery is not been made yet, Lordship.
No, see, no.
That's the ground he is still in the custody. The records Lordship is revealed that is being his UPI code is being used by the Lordship main
Rajasthan.
accused, yes, Lordship.
Yeah,
It is their Lordship.
phone number belongs to the mother of their main accused.
Okay. How long has he been in custody?
36 days today. No more custodial interrogation. Hardly.
He'll cooperate.
Lordship, then strict condition may be imposed, Lordship, because
He will not use his He'll not go back to the same thing again. Any indication, you are liable to
Correct.
cancel his bill.
Yes, Lordship.
He'll cooperate with your, what do you call that, investigating officer.
Yes, Lordship. And also the recovery amount, if whatever it may be,
How
Lordship.
can I put that here? That will be too much.
Yes, Lordship.
I'm just keeping this.
Yes, Lordship. And also,
Madam, under the thing.
this is
Anything
also
more?
there. Also, there is recovery only, the seizure items, Lordship.
This boy has fallen into trap of a friend.
He is not fallen into trap. A story has been made out which is now projected that he has fallen into trap. He's the culprit.
Whatever, Lordship, I want kindly, Lordship, my objection may be recorded.
Yeah, we'll surely do.
Well, except that local surety.
That local surety.
Local surety may not be aided.
Why?
As he's from Tripura. Lord.
Then it is more risky,
That
Lordship.
we will not. Otherwise, his presence would be difficult. This sort of people view local surety will be required. You will have to. Now I'll ensure. Now I'll ensure 2 local sureties.
Well, this boy is a permanent resident.
He says that he is born and brought up in Gangachara. Here only then. And he will not leave the jurisdiction of the court without permission.
Well, that part may not.
That I will enforce.
As and when.
No. That you apply, you take your pick.
I can understand the predicament when it is.
I am giving you bail because he seems to be used.
Yes.
2 local surety.
That
Not
will be-
to leave
No, that will be
the
irony.
jurisdiction of the CJM. CJM,
UPR, Lordship.
UPR.
Well, kindly, that 2 will be very difficult for this boy to find.
Let him be there inside.
At the most, 1. Kindly.
1, okay.
Otherwise, purpose will defeat 21 again. Everybody is young at heart in
But I'll also have to be satisfied that his presence would be there during the end. That you can't, neither I can, only this can.
Only this can. That's why 21 is always young at heart.
Not to leave the jurisdiction of CJM, UPR, na? Okay.
Like this.
Great.
This was a mujhe dil se. Yes.
Where is my case is Lordship, the private respondent Lordship. Private respondent Lordships.
Much time.
Not
We'll
much.
cut short the thing. Your only case is that she was not initially shortlisted
Yes, Lordship.
for farm manager, and in the second case for
First
laboratory
case-
assistant.
Yes, first case Lordship, program assistant Lordship.
Be that as it,
Lordship. Same issue Lordship.
same issue.
Yes, Lordship.
They were not shortlisted.
Yes, Lordship.
So how come they came up for the interview?
Yes, Lordship.
Now they have filed affidavit.
Yes.
In the affidavit, they have explained
Explain.
as to how this has happened. In one case, farm manager, 2 persons had withdrawn.
With 3% withdrawn Lordship.
Okay, then 2 came in. That
Two
is why
came in.
these 2 came in.
But Lordship, 1% is not
Hear
considered.
it from me, then give me my clarification. 2 persons withdrawn.
Okay.
So 24, 25, the private
Yes.
respondents came in.
25, 26.
The second case with regard to that program manager or something, it is that this lady had got 25 point something,
Yes, Lordship.
but while preparing the shortlisted thing, her marking was shown as 15.
Yes, Lordship.
So by giving her 25, she comes at serial number 6
6.
above you all.
Yes, Lordship. As per their claim Lordship.
Now you show me the disclaimer.
In Lordship, item number in Lordship, if there
Case
is
number,
a-
case number, case number.
Case number Lordship. Lordship, past Lordship, case number Lordship, 354 Lordship.
Okay.
354 Lordship. I'm straight to their reply Lordship.
Hmm.
In any cases Lordship, they constitute a board Lordships. This case Lordship, the board is not constituted Lordships. For example, Lordship, they annex their own documents.
Mr. Counsel,
Lordship.
let us not go into all those nitty-gritties.
Lordship.
Come to the issue. The ground.
126 lordship, page 126 lordship. They, they are documents lordships.
126. Okay. Okay, 126, yes.
Lordship here, lordship, page number 118 lordship, sorry lordship.
180.
Start from some of the candidate lordship, 3 candidate lordships. Withdrawn their candidature lordship from the interview lordship. They intimate lordships.
In this affidavit, they have covered both farm manager and lab
Yes,
technician.
everything is there lordship.
Yes.
Same affidavit lordship.
Both.
Yes, lordship.
So one affidavit will cover both.
Yes, lordship. Lordship here, lordship. Lordship. Last portion, last lordship. Your faithful, your sincerely lordships. Only one person is signed. Lordship. Signature is made by only one person. Lordship. Name Take Time.
There was a list of candidates shortlisted. Where is that list? Initial list.
Shortlisted in my read petition.
Read petition. Show me that.
Shortlisted in my read petition lordship. Page number lordship.
Farm manager.
A program assistant lordship. This is a program assistant case lordship. Shortlisted lordship. Page 30 lordship.
Program assistant, lab technician, right?
Yes, lordship. Yes, lordship. This is program assistant lordship. So lordship here lordship, one person is withdrawing.
Who is the person withdrawing?
Name Take Tai.
Where is he?
Serial number lordship 2 lordship.
Take time.
Yes,
Where is that letter? You showed me 118.
Yes, lordship. 118 lordships.
Okay.
Their affidavit lordships. And other.
But this is farm manager.
Yes, Lord.
118 is farm manager.
No, lordship. This is a program assistant lordship.
Farm manager. Project is post of farm manager. Withdrawal is in the post of farm manager. Come to 118.
Yes, lordship. 118 lordship.
Surrender of candidature for walk-in interview for the post of farm manager.
They intimating lordship, farm manager, but lordship, here lordship, I intimating farm manager. Yes, lordship. They are not withdrawing lordship. Otherwise, this is not withdrawing.
I am highly regretted to inform you that I shall not be able to so and so. So kindly surrender letter for the same. Someone who is more competent may release.
Yes, Lord.
So Take Time, he is at serial number 6.
6 lordship. No, serial number Take Time is lordship, here lordship.
I Mr. Come to 29. It is a post of farm manager.
Farm manager lordship, in other case lordship, I'm on other lordship.
This withdrawal is happening in farm manager, not in personal assistant or that program assistant. Come to page 29 of your petition. The 354.
Yes, lordship. 29 lordship.
Come down. Name of the candidate for the post of farm manager.
Yes, lordship. Farm manager.
Right?
Lordship.
So you find that total 24 people were incorporated.
Yes, lordship.
Including the petitioners.
Yes, lordship.
Right? Now they say Take Time had withdrawn.
Yes, lordship.
Along with one Nage Yogam.
Yes.
Right?
Yes, lordship.
Nage Yogam.
Yes, lordship.
Now there is a corrigendum at page 120 of the affidavit.
Yes, lordship. Corrigendum is there, lordship.
Now the corrigendum says Take Time 6 and Nage Yogam 24 have surrendered.
Yes, lordship.
Now 2 posts surrendered.
Yes, lordship.
So the private respondents are at 24, 25 and 26.
Yes, lordship.
Right?
Yes, lordship.
25 and 26.
Yes, lordship. They are there, lordship.
So now they come in. What is the mistake done?
Lordship, first lordship, they are not providing these documents at the time of the.
Forget it. Now you have it, so you don't have a case.
Yes, lordship.
You agree? Now no case.
Yes, lordship. After this affidavit only, lordship, I came to know that this.
Then why argue? Why argue? Withdraw.
Lordship, one is for one post, lordship, for 8 candidate lordships here in East, lordship.
Oh, they were. I had this doubt.
Yes,
then I went deep. 2 candidates withdrawn, 2 candidates came in. Finished. That's the end of the matter. Now you come to personal assistant.
Personal assistant, lordship, it is the mistake. If this is accepted, lordship.
But where is your dispute? You dispute. You have not disputed.
Lordship, disputed, lordship. At the time of this filing of this lordship.
Where is your dispute to the contentions raised? Materials brought on record in the affidavit.
Affidavit, lordship, they are brought, lordship, but this is, there is,
Counsel,
this lordship.
there is nothing now. Sorry. Whatever you have said, It's all been dealt with.
Yes.
2 persons for farm manager, 15.5 wrong recording. They have brought the calculation sheets also. She should get 25. She'll come in 6 above you. And she has been selected. What?
Yes, this is the
Because
case
you
for-
have no other grievance with regard to this election.
no.
Only this is the ground.
Yes, this is the ground lordship.
That-
My ground is clarified by this affidavit lordship.
Me to dismiss it?
Lordship, yes, lordship, dismiss it.
I'll
lordship.
dismiss it.
Yes, lordship.
Okay, dismissed. Parties name le lena. I'll pass the order, but you'll get it next week only. Too much workload.
No, no
Next
problem.
week.
Much obliged.
दोनों को dismiss. ये order हम pass कर देंगे. You have anything to improve his case?
No. Deeply always.
नाम ले लेना. Just give your names, parties
Yes.
which you are representing. Yes. Amount 20%.
Yes, Lordship, 20%.
Oh, no. 20% only. What is this?
Lordship, there's a check bound case before the London JMFC matter. So, as an interim compensation, 20% was given by.
Yes. Why have you not paid? There is another matter coming up. Same party, I think, on.
That has been disposed of, Lordship.
No. It's fixed on 13th.
No, Lordship.
Yes. 13th. Fixed on 13th. Hey, मेरा रूम में क्रिमिनल फाइलिंग मैं जो बैठता हूँ ना बैक साइड में क्रिमिनल फाइल रेड कलर फाइल में same party there is another case madam.
No, Your Honor, Your Lordship, this is the only matter.
Only matter.
Yes. There was one, but it is already been disposed.
Who disposed? I.
Just,
No,
sir, Lordship.
The disposed of in what manner?
In a manner, Lordship, that was remand back saying, because since there's involve a fake of caution, that has to be decided by lower court only, Lordship. The High Court, under 482, it cannot be decided.
Your Lordship, we have not received a copy of the affidavit in opposition yet.
Yes, what is your ground here?
Lordship, here the impugn order is on page 77, which they have challenged before this honorable court. Lordship, the trial court saying that since they had a sufficient amount to pay the amount, so they have imposed a cost of the interim measure 20% has been paid. And Lordship, going through the in the petition also, Lordship, if I take Lordship just for a while, Lordship.
Where is the order passed in the other petition?
Your Lordship, I'm appearing on behalf of T. Sunil. The leading counsel is out of station due to some.
Either does it may 158/2023. That is the other case, Mr.
That has been disposed of 18/11 of 2024 by Lordship. On by
18/11/2024.
yes, Lord.
A copy मिल सकता है क्या?
Criminal petition 158 of
Criminal petition 158
of 2023.
of 2023.
Three.
What was the order passed there?
Lordship, since there's a fake, there's a fake dispute in fake, that has to be only tried by the lower court, by the trial court. So that has been remanded back.
इसका अंदर में रख दीजिए. When is he coming back?
After court vacation, Your Lordship.
Oh, then you argue.
No, Your Lordship, the matter may be.
You
fixed
argued.
after-
You argued well today. There was another matter you have
No,
not
Your
today. That
Lordship.
day you argued. When? Monday.
No, Your Lordship, I humbly pray after court vacation.
No. Court is not on vacation. Court is never on vacation.
Then Your Lordship, the matter may be fixed after 24 of this December only. Since the leading counsel
After?
is 24th of this December.
24th, 25th, then you come. I'll come online. I'll be online.
Your Lordship, the leading counsel is committed in another various cases, so.
On the prayer of made on behalf of Mr. T. Sunil, learned counsel for the petitioner, not objected to by Mr. Damu, learned counsel for the respondent. Registry to list this matter.
Lordship, I have a small prayer. Since Lordship, I have no issue like if they take time because Lordship, but because of this Lordship, there is
Whole
stay.
proceeding that case is getting. cleared.
That has been stayed, Lordship, not stayed. The learned trial court has like because of this pending hold has stayed the matter,
I
Lordship.
know, understand.
This is
We'll
the-
have it on 9th, 9/1/2024. No further adjournment shall be granted in the matter.
And Your Lordship, the interim order will be continued.
That's difficult. Interim order passed earlier to continue till the next date of this. 158.
158 of 2023. It's been-
158 of 2020. Just put it inside this.
Thank you,
Obliged.
Vice.
But two things in this petition. The
Who
first,
are they? Who are they? What is their
well,
nature of the service discharged by them?
a junior teacher,
Huh?
junior teacher
Junior teacher.
in the Department of Education.
So they are a government employee.
They are a government employee defined under Section 21. Now, in the BNSS, it is Section 2.
Charge is also pertaining to prevention of corruption.
Correct,
No.
my lord. So therefore,
19.
yes. So, my
No,
lord,
is there a charge? Where is that charge against them? Where do I get it?
my lord, I will have to establish from the facts so that I go.
No, I just wanted to know the charge against which they have, charge sheet has been filed against them. 13-1.
30. Page 30.
Page 33.
33. 33.
33.
Now, my lord will.
Now, what is this Maga Hukum doing?
Maga Hukum is a junior teacher, my lord.
Junior teacher.
Yes. Cashier. He was at the time of commission of the offense, he was a cashier.
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 A regular
But-
employee.
Regular. But his substantive post is junior engineer, my lord.
Junior engineer.
Junior teacher, man. Now
Junior
he's
teacher.
postgraduate.
Okay. And Takehali?
He is a PUT,
Huh?
MTS, office assistant, I think it is.
So once the corruption charge has prevention of corruption charge, you say rightly done because they are government employees.
Government.
So what about 19 then?
Then, my lord, that's why it comes, once you invoke section 13, then
19 will come.
19 will come. So it is a case of predicate offense. So without prior sanction, you cannot proceed with.
Yes.
Number two, my lord, no prosecution sanction was sought for. And there are judgments by this High Court, and some of the cases, my brother has appeared in this case. Well, in Justice Ansari in 2010.
No, just a moment. Mr.
If the court do not have the power to take cognizance,
It is gone.
go. There's a bar on the.
Yes, my lord. My lord, I have cross-checked the documents, my lord. The LCR.
Mr. Padam,
I have
you
not found-
accept that these are public servants?
My lord.
13-1 has come in.
My lord.
So without resort to 19, 197, there is a
Yes.
scope.
Yes,
But
scope, yes.
19, do you have that scope? I'm asking a query. It's a genuine query.
No, my
No
lord.
scope.
No, my lord.
Then
I have cross-checked. I have not found.
why have you not sought sanction? Seek sanction.
My lord.
Proceed then after. We'll have to quash this order then.
My lord.
The order under challenge is 4-9.
But what?
Whole proceeding law.
No.
No. We'll only say
He's asking for.
that the initiation of charge has been framed.
Yes, my lord. The trial is going on, my lord.
We will say that this cannot proceed till the prosecution sanction is received.
My lord.
Correct, my lord.
Because this is an issue you can take up at any point of time.
Correct.
Yes, what are the decisions?
Well, the decisions I would refer, I will refer to this, my lord.
Not refer, give me copies.
I'll furnish 2000, you have 2023 to GLT.
2023 to GLT.
GLT is 885.
885.
Correct.
Decision of?
This is Huzer Lolen by Justice Thakuria. Then another, well, this paragraphs are.
It follows 2016 Supreme
Yes.
Court.
Yes.
2016 has been followed.
That's quoted here. Then, my lord, that.
What is the name of that 2016?
This, 17, that Prabhat Bhai Ahari case, 2007.
Gujarat
Yes,
case.
yes.
Hmm.
That is in paragraph 20. My lord, that another judgment where it is important is this, my lord, 2023 4 GLT 776. Indranil
23,
Barua,
4 GLT
76.
7.
776.
Oh.
This para 18, 22, 23 club. And my lord, most important judgment, which 2010 1 GLT 511 para 13 and 15. Now, my lord, the proposition is in this, that's rendered by Justice answering law. The proposition is, my lord, when a court do not have the power to take contingency, cannot proceed with
Section 19, it's
Yes.
very,
And
very
number
clear.
following that, my lord, the another line which Justice Ansari finding is that if the court do not have the power to take cognizance, he cannot discharge also.
Okay.
That is para 15, my lord. Well, just I read out the lord, para 15. That's very important judgment.
So the challenge in the present proceedings is two orders.
Well, we have challenged all proceedings, but my lord can keep open the scope that without prosecution sanctions, no further trial will start. Otherwise, my lord, that
28-9.
regular offense, my lord, that can always be.
28-9. But this thing happened in 2014. Why are you now before us?
Now, most of the witnesses have died.
No, that's why you waited for them to die before instituting a.
No. When the matter remanded, then only they approached.
Well, this is a 2011 case.
2011.
Matter remanded?
Because from there it was committed from Basar, it committed to here, then the client.
That is why you have taken a plea that it's too far away from me to attend. But thing is that cognizance was taken in 2014. Why proceedings in 2024?
There were no trial at all because the presiding officer at Basar was one of the council.
That is in 2014, 15.
Thereafter, thereafter there was a notification designating this district and session court as a prevention of corruption court, a special court for DC Act.
Charge was filed in preferred in was framed in 2015. Then why the delay? No trial, no examination of witnesses.
Nothing.
Sure.
Yes, kindly see page 39. Copy of order.
I think some of the witnesses have been examined, I think.
No, but I'll go by the present situation only. At page 39.
How many witnesses have been examined till now? Yeah, give it to Mr. Parag. Give it to him.
Well, that lordship's answering judgment, which is a catching point for me, is very, very important. But just, my lord, can we afford me this moment? No, that's also there. What is now of paramount importance to note is that when a court proceeds with a case where no cognizance could have been taken without sanction, entire proceeding of such a case held by the court would be without jurisdiction. Consequently, in such proceeding, the court will not have the power to frame charge, and when a court does not have the power to frame charge, the question of court discharging the accused facing a trial would not arise. That is a beautiful line. Well, I still remember when that.
Mr. Oscar Junior, to give me a list of these books.
I am furnishing.
Copies.
Yes.
Copies you get?
Yes. No, today we'll give it.
Or you give it to her, they'll take it out, don't worry.
Yes.
Just give that list of books and the concerned paragraph. And give me that 2016 and 2017 Supreme Court.
These are forward. That's why, my lord, the first thing, explicit bar under section 19. Then number two, my lord, what had happened? Normally, whenever under the trial, under such trials, the 209 CRPC, all CRPC is involved, that committal stage. Just, I do not have the power to take cognizance or franchise, so I'm committed.
Whatever steps they have taken, everything will go.
Well, they, my lord,
But Mr. Pada, I'll record your statement that both of them you admit are public servants
Fine.
covered by 21.
correct, covered by 20, and this
This
is of them.
You give me that judgment.
Correct, grateful, but
Mr. Tana, just give me that 2016 and
17 Gujarat case. Prabhat
Gujarat
Bhai
case, huh?
Ahari.
16 was,
I remember that Prabhat Bhai Ahari judgment.
oh no, there is a judgment prior to that, specifically on section 19 of
Correct, Mr.
and its a relationship with 197. 2-3 paragraphs, beautiful paragraphs are there. Just
Correct. Grateful.
this person. But Mr. You will not get this order before next week. You can apply for your copies, but order will come Monday or Tuesday.
That's fine, my lord, that's.
May I please, my lord?
My lord, also TCR was called on last occasion, called for on last occasion. My lord, this criminal petitions jointly filed by the both accused and victim for passing of FIR and charge sheet.
Yes, Mr. Ade.
Your Lordship, TCR has been received as per the, Your Lordship, the cause list, it has been reflected. The offense involved is a grievous injury, Your Lordship, which punishable is extended to 10 years, which may go up to life, Your Lordship.
But the learning council for the parties. The trial court records have been received. Anybody appearing for the petitioners are here. You will be representing all. List this matters
Yes, ma'am.
after the ensuing vacations for admissions.
Obliged, Your Lordship.
All right.
Marvelous one. So, my lord,
The other one has come, item number, some matter you mentioned.
yes, my lord, along with this item,
Anything
item
else?
number 19, I have mentioned this morning, this is my lord, criminal petition number 158. Both the case are my lord.
But in your affidavit also, it is clear that they have stolen the matter.
No.
If they have stolen, they'll have to face.
My
the
lord,
consequences.
what my contention is that.
There is
That,
no
my lord, what had
contention here.
happened, that, my lord, we admitted there was there. So, my lord, in consequence of that, there was a
First,
settlement.
Mr.
That
first,
settlement
Mr.
was met.
So
within
I'm
the
not,
village.
I'm not quoting it. We'll have it for admissions. But ये 157 के साथ item number 158 supplementary list में आया है.
Now, matter is pending before the lower court at the 313 stage.
I'm not interfering.
Yes, prosecution.
I'm not interfering. I'm not passing any interim
No,
order.
no, already staged there.
State.
Yes, as per order dated 24 9
So it
25.
was stayed at the stage of 313.
Yes.
Mr. Modi, complete the proceedings. Because you have admitted that you have stolen. Once you have stolen, how can we? You ask us to quash a proceeding like that.
My lord, basically what I have
He
protested.
seems to be a very. And now 158 has come, that goes a step further. Gas cylinder, induction. These things.
Both the cases are similar.
Don't ask us to. Husband, wife fighting out, coming out after reconciliation. Okay, fine.
No, my lord, that is not there.
Then
Here in this case, my lord, this.
you complete the trial. We are not convinced.
Since my lord in the trial stage, the trial court is also my lord recognized that these the parties are already settled the matter
Fine,
outside the court.
you go ahead and.
Now the
finish it off.
stress in this case is that
We'll vacate the interim orders. You go, let the trial be completed.
Then interim may be vacated.
We'll vacate it.
basically what my lord I have projected is that both the now the two accused and the
Tomorrow, there is a
informant are
theft
charged.
in your house, the thief goes away, he comes back, and you enter into an agreement, that will be the end of the matter. Is that the power we have under 528 or 538, whatever it is of the B 528 of the BNS or 482 of the
This accused admitted of committing series of offense.
of theft
Series of offense of theft in that particular place.
earlier also.
Yes.
So
On similar night also.
if I
the same
pass
night.
something, it may prejudice you in the trouble, trial. Withdraw it, complete the sittings. Up to you. I can pass orders, there is no problem. I'll quote your settlement deed and say that you have admitted to have made the theft. That will keep you in problem in the lower court. Finish it off. Finish off the trial, that's all. Because if I have to pass an order, then I'll have to quote paragraph 2 in both the agreements. And that will be the dead knell for you. If the tribunal, if the court is in favor of you also, by seeing para 2 finished. That is your admission. There is no story made out.
My lord, what I'm trying is, my lord, whatever that, what it is on my lord that admitted. But out of that, my lord, within the settlement, within the,
Mr. Counsel, you have admitted to have made the theft. You have not said
for that,
that
my
this
lord,
was done under some other, any other story. That we wanted to, she had done this to me, so to take revenge, I had brought this. You are projecting yourself as a thief. Something story was there, then it would have been, we could have come in, but there is no story here. So we are not interfering. You want me to dismiss it? But I'll record that. Even in the settlement deed, there is nothing.
my lord, I will prepare order, my lord. Order, my
You want an order?
lord. My lord.
Okay, Likha. But Mr. C. Modi, learned counsel for the petitioner, and Mr.
G. Tadu,
learned additional public prosecutor appearing for the state respondents. So the petitioners, by way of instituting the present proceeding, has prayed for quashing of the FIR. So filed by the petition number 1,
Petitioner number 3.
petition number 3 against the petition number 1 and 2, leading to registration of Pasigat PS case number 159/2020 under section 457/380/34/411 IPC. So the petitioners have also you have not challenged the charge sheet. Not challenge the charge sheet. Then FIR is no more. It's a charge sheet that is going on. Then
I'm basing on, my lord, this settlement agreement.
no, you cannot. Why have you not challenged the? How can I interfere with the FIR once a charge sheet has been filed? Please explain the position to me. Can I? Once the charge sheet is on record, if you don't challenge it, that's the end of the matter. Yes, Mr. Tata, what's the position? What is the position?
Position is now 4313.
No, no, no,
Pen-
no, no, no. But the charge sheet is not under challenge.
Yes.
And only the FIR. FIR is now converted into a charge sheet.
Yes.
Investigation is complete. We have
Completed.
gone beyond that.
Yes.
So
Trial also.
I'll have to also look into the charge sheet now. But that charge sheet is not under challenge.
Yes, it may be dismissed. Because after charge sheet,
Somebody, what is the
becomes
position? What should this court do in such circumstance? As an officer of the court, I'm asking you. What should I do under such circumstance?
So, my lord, noting them, my lord, whatsoever, my lord, if my lord feel appropriate, my lord, matter to be dismissed.
No, you have not challenged the charge sheet here.
Well, I admit that part. No,
Then what should I consider? How can I just consider the FIR without taking into consideration the charge sheet? Charge sheet is against you.
he has to challenge charge sheet as well as GR proceeding.
GR proceeding is there. I'm challenging the GR.
GR case is nothing. GR case is initiated when the case is taken up at the first time. But what is important is the charge sheet. Well, am I wrong in saying so? I don't know. That's why I'm asking you.
His matter is at the bars of.
Yes, Ms. Jenny. What should the court do in such circumstances? The FIR is under challenge. There is already a charge sheet filed in the matter. Forget the proceedings in the charge sheet, but there is no challenge to the charge sheet.
Lordship, in such circumstances, Your Lordship, normally after the FIR has been charge sheeted, the FIR becomes a substantial evidence.
So
the
thing would be the charge sheet.
charge sheet.
Mr. Modi, you withdraw this, file afresh with the challenging to the charge sheet. Mr. Modi, C. Modi, Learned Counsel for the petitioner, and also Mr. Mr. Additional PP appearing for the respondents. Mr. Modi submits that the petitioners inadvertently had failed to make a challenge to the charge sheet filed in the matter, and accordingly submits that he be permitted to withdraw the present petition with liberty to file the same. With liberty to the petitioners to file the same if so advised in a proper form. Also, prayer accepted. The criminal petition 157 AP 2024 and 158 AP 2024 stand with dismissed on withdrawal. However, with liberty as prayed for. Interim orders passed away to stand vacated.
All right.
Why have you not filed the dusty affidavit?
I filed.
When?
On 4th.
Oh, okay, affidavit. Wait. So, seen the office note dated. This will be in IA C 161 AP 2024. Dated 6/12/2024, which reveals that the appellant has not filed the affidavit regarding dusty service upon the sole respondent. So, however, the Learned Counsel for the appellant submits that the said affidavit was filed on 4/12. So, raised it to trace and tag the affidavit so filed along with the records of this case and list the matter again on when. It's not on record.
I'm so extremely sorry, Mother. I had handed over the affidavit to the advocate's clerk.
Or he may not have filed it. Check up. List this matter again on next week, 17, 18.
Oh, last week.
Yeah, Lordship. Lordship, lower court report has received.
You forget it. Come to this. Come to your facts here. This is squashing. Forget the lower court records. We will take it. Now, what I find is, Madam Ginny, you also just see.
Yes, your lordship.
There is an agreement.
Yes,
Hmm? But the agreement does not have the two victims.
yes.
Two victims are missing.
Of the FIR.
How can that be a?
Also, your lordship, on the first occasion, the objection that was made
Hmm.
is there are two parts in the FIR. First is assaulting the doctor who's the complaint.
Ah.
You know. The second is the damage of the ambulance vehicle.
Hmm.
Now, since therefore the PDPP Act comes, your lordship.
Hmm.
Now, can the complainant, not being an authority of the public property, come to a compromise with the
No, we
accused?
cannot.
Yes.
And see, it's not there. That compromise by that lady, wife and the driver. I think they are not there. Where is that? Where is your agreement?
At page number 48, your lordship.
Okay, this is by the doctor.
Yes.
So this is with relation to the first part.
First part.
But what about the second part? There is nothing. So, Mr. Counsel, how is this criminal petition maintainable? There is no agreement. And how can he, with regard to public property, I can understand the doctor. Tapu Sindhu has done this, okay, fine, no problem. But there is another part wherein the vehicle was damaged, the driver was injured, and his wife was also injured. The three aspects not covered.
But possibly it's amicably settled.
Forget it, no amicable settlement, and the whole matter is now stayed. What is your name?
SMC,
Where is your senior?
out of this.
Out of station. We'll have it tomorrow.
Or
Tomorrow, he'll be here. Day after. At the Learned Council for the parties, the Learned Council for the petitioner submits that the arguing counsel is not available today and prays that the matter be taken up on Thursday. Huh? Prayer accepted. Registry to list this matter again on Thursday.
Deeply.
You are appearing for the university.
Yes.
Yes.
I
Forget it. Forget the IA. You will go for WPC. Madam. Yes. What is your case? What do you want?
So this, through this case, I'm challenging the.
Where is that Act of 2018 copy?
Yes.
You have?
Yes, I have. Yes, that's it. The first page.
When did this University Act come into being?
It is of 2012.
12.
Yes, and this is of 2018.
But this will not cover a university.
It will cover your lordship. Now, your lordship, if we look at the very heading of this,
That would be autonomous bodies directly under the control of the government. This university cannot be said to be directly under control of the university.
No, but even then it's under the control of the government because the whole fundings are done by.
That is not control. University has its own statutes.
Now, your lordship, if that would have been the case, then even the post of vice chancellor, this would have been recruiting that post by
Vice Chancellor is not appointed by the government, it's appointed by the governor, who
Yes,
is the Chancellor to a search committee. It's not by the government. Government may have influences. How can you extend this concept to such a law?
No, now your lordship.
What is the problem in you? You're a candidate.
Yes, I'm a candidate.
You're a
Now-
candidate, you have applied.
Yes, I have applied.
Show me that application.
It is in Page number 24, Your Lordship, Annex 3. That is my. Now, there's one particular thing that Your Lordship, I would like to point out. In their advertisement, Your Lordship, page number 19. Page number 19, the note is there.
Okay, just page number 19.
Yes,
Yes.
the fourth point, Your Lordship.
Oh, wait. 19. Yes.
The fourth point.
Hmm.
There is no provision of re-evaluation or rechecking of answers script. In respect,
That is.
that is there.
Now, maybe that.
Now-
What? How does that take it out?
Yes, now what I'm saying is that by conducting examination on their own and not handing over to the competent authorities, there's malafiding.
Why? What is your nobody else is having this problem? Why are you having a problem?
Now, I'm here to voice this concern.
You is it a PIL? Is it a PIL?
No.
It's not a PIL then.
Now, Your Lordship, the other person, nobody comes before the court, does that imply that there is no wrong? Now, had there
And
been-
the University Act itself provides that the appointments would be made by the university, not
Yeah, there is no dispute regarding this here.
then.
The appointments.
Why
that we
should
made-
the university be subservient to some other body?
Your Lordship, this is not the issue of the appointment. The university is the appointing authority.
Appointment also includes within it the selection.
No, yes. The issue here, Your Lordship, it's not about the appointing authority, Your Lordship. The issue here is the exam conducting authority. Ultimately, it is just like the APCS, Your Lordship. The APCS conducts the examination and the organization they used to appoint. The similar pattern should be followed here. I'm not questioning here the appointing authority. That is not question. And one thing is
Yes,
that.
what is your stand? University.
My lord, the university is autonomous body. This came from the Act 2012.
And the act says notwithstanding anything contained in any other act in the
Yes.
state.
Only
This act will have
the
different.
government, they have given financial aid. Other than that, nothing.
You're finding it difficult.
All the recruitment route has been done by the
Mr.
university.
Panning, what is the character of this, this selection board? What is that called?
APSSB.
Assam, like Arunachal Pradesh
Staff selection.
Staff Selection Board. Is it such a body that even universities will come in? State universities will come under its purview?
I don't think so.
It cannot.
It is only before state government employees.
Autonomous means autonomous in bodies directly managed, controlled by the state, corporations. Those are autonomous bodies, but it is totally under the control of the government. They may have a board of director, but that board of director is a government body.
Now, if we look at section.
Okay, we'll have come back at 2. Satisfy me. Otherwise, anybody waiting for the hearing matters?
Your Lordship, then kindly tomorrow. Please.
No, today. Today.
I am waiting for 2 minutes.
Which one?
29 and 30.
Will be difficult today because too much of matters. We'll have it.
Your Lordship, kindly.
I've gone through it. Let us have it after vacations.
Tomorrow, Your Lordship, my matter tomorrow.
Your matter. Tomorrow. After
And
vacation.
I will inform Mr. Padley.
You just, inform Mr. Padi. I think once we touch this matter, that second appeal without a question of a substantial, I remember that. There was no substantial, he was supposed to apprise us whether there would be a substantial question of law.
Second one, my lord, this is, I am apparent here, the degree was not challenged.
Challenge, okay, fine, we go. We'll have it
There was-
on the prayer of the learned council for the parties 29-30. Raised it to list this matter again on, we'll have it on the first week or second week?
Second week.
January. 9th? 9/1/2025. And 31.
My lord,
32,
my lord, 33 and 34, my lord.
10. Just have it confirmed from Mr. Patil. If he has any date problem, you just give it to him. 33 and 34, when do you want it?
My lord, after vacation, my lord.
Who is for the petitioner? You're for the petitioner.
No, I'm for respondent, my lord.
Who is for the petitioner?
Well, he's there
Okay, let
virtually.
them come. Let them come. 2 o'clock we'll
My
see.
lord. My
Your
lord.
day.
I have different. Well, item number 1.
What?
My lord, in this matter.
33, 34.
Yes, yes. Counsel, senior counsel, Mr. Rohan Shah is appearing from Mumbai on VC.
But today will not be possible. Today. You have a convenient date, give it to her. Okay?
Well, item number 1.
Today we are full with done. Whenever it's convenient, talk to Mr. Boro also and then
My
fix it. Give it to him. Adjourn, date. Yes.
Yes, my lord. Item number 1.
Hello, bless.
Maybe I have got instruction from a client. I think we'll withdraw the matter and with liberty.
Item number 1. Mr. Tariq, learned counsel for the learned counsel for the petition on instruction submits that he be permitted to withdraw the present writ petition with liberty to approach the respondent authorities. Prayer accepted. Let it approach. What is it? Prayer accepted.
Instead of respondent authority, my lord.
That you can't come back here with this. This I'll not permit that. Respondent authorities. Full stop. Prayer is not objected to by Mrs. MS Ete, learned government advocate appearing for the respondents number 1, 2, 3, and 9. Full stop. And Mr. M. Kato, learned respondents appearing for the learned DYSGI appearing for the Union of India respondents. Full stop. Withdraw.
If it is to approach the respondent, then my lord, that can be hard on merit. Because it's passed by deputy commissioner, my lord.
You can approach the director, you can approach the government.
My lord.
If I have to hear it, I'll have to dismiss it.
Yes, that's
respondent authorities against respondent authorities. Full stop. Prayer is not objected to by the learned counsels appearing for the respondents. Full stop. Accordingly, writ petition stands dismissed with liberty as prayed for. Because there is nothing. I was only worrying that if they have something and I come in and pass this order, then it will be a double finding of facts. It will be difficult for you. Now go ahead with the government. If you can work out something, work out.
My lord, my lord, in item number 33, 34, there is interim order.
33, 34, interim orders passed earlier. When do you want it?
That I'll
just give
inform that
interim orders, madam, is going extended.
Most obliged.
Sir, just a second. 28. We'll have 28, then come back to you. They are here. Call them. हिंदी आपका नाम मैडम आपका नाम अभी आप कहाँ रहते हो कब से नहीं कब से शादी कब हुआ था 2010 उसके बाद इंसिडेंट हुआ इंसिडेंट के बाद कहाँ थे आप घर चला गया था चला गया फिर आप लोग दोनों अभी साथ में हैं नेक्स्ट टाइम ऐसा हो गया तो दोनों के लिए दिक्कत होगा इस बार आप लोग को हम एक साथ रहने देंगे लेकिन नेक्स्ट टाइम ऐसा एक इंसिडेंट हम लोग का सामने आया आपको विड्रॉ भी नहीं करने देंगे उल्टा आपको अगर विड्रॉ करना चाहेंगे फिर हम करने नहीं देंगे आपको आपका अगेंस्ट में केस करेंगे फिर तो दोनों मिलकर रहो बच्चे कितना है 2 और क्या चाहिए उनको देख के मैं क्यों भाई वो तो फिर लिफ्ट अच्छा से आराम से रहिए हाँ आप क्या करते हो? बिजनेस। मैडम आप क्या करती हो? हाउस वाइफ है। बढ़िया। लुक आफ्टर द किड्स, देखिए अच्छा से रहिए, ठीक है, एक साथ रहिए, विल पास ऑर्डर्स, ठीक है, आप लोग जा सकते हैं। ओके।
Deeply obliged.
In terms of the directions passed by this court while the order dated 5/12/2024, the petitioners have appeared in person before this court, and this court had an interaction with them. Also, the petitioner number 2 has submitted that after the incident involved, she had started, she was cohabiting with the petitioner number 1 as husband and wife, and they are continuing to do so. So it was also submitted that they have 2 children, full stop. Accordingly, we'll pass the orders. Today will not pass, next day will
yes.
pass. Accordingly, the registry is directed to list these matters again on Thursday for delivery of orders. We'll have it on Thursday. Madam,
Thank you,
इसको
sir.
भेज दीजिए Thursday में order pass करो। नहीं।
Much obliged.
Yes.
Your Lordship, on last occasion, CD was called for Your Lordship. The
You have gone through it?
yes, Your Lordship. The complainants, it seems that on 2 occasions her statement was given, Your Lordship. Both the statements are contradictory. On the first occasion, she stated that she was raped, and on the second statement, she stated that the FIR that she has filed is false, Your Lordship.
No, there is a reason for that. If you come to the mutual agreement settlement, you will understand.
Yes.
Yes. When the petitioner number
1 is the complainant.
1
Yes.
had lodged the complaint, she was married to somebody else.
She was actually wife of somebody else.
Okay. Where is the talak? You have a nikah. Where is the talak?
That
You have not mentioned anything about the talak here. In a Muslim marriage without talak, you can't have a fresh nikah. You have mentioned about the nikah
yes.
at para 4, but where is the talak?
But they misfired, they misplaced the record. That's why.
We can't help it, sir. We are not coming in here.
No, your Lordship.
This is a heinous crime.
Only problem is here it is not a heinous crime, but the allegation as per the section.
Sir, that lady was not his wife at that point of time.
At that time, she is
If
married
this
to
is the
someone.
system, somebody will commit rape, then marry. Will you condone that action?
No. Basically, Lordship, here it is a matrimonial dispute. Like
what matrimonial dispute? You were not married at that point of time.
No, she was married to
somebody else.
Somebody. Then that husband, his ex-husband, pressurized her to. Actually, ex-husband has a illicit relation with the elder brother, elder sister of this complainant.
Be that as it may, illicit relation to all these things. All these things, please get it resolved in the trial court.
Lordship, they are all the way from Gujarat, Uttar Pradesh.
Be that as it may, we are not coming in.
So, since the matter has already been out of court, has been
show me the talak. When was it? That thing is mentioned here in your deed of settlement. Where is your nikah registered? When was it registered? Who registered it? How you registered it?
Lordship,
nothing. And Muslim marriages have to be registered.
No, Lordship, only dispute is here in.
There is no dispute. First, satisfy me on
this. That was the history actually. The
yes.
Complainant, he married to that particular person, ex-husband. That is not the dispute here. Here.
No, okay. When was that marriage dissolved.
He was married, so they did not.
It's
hear,
very
but
difficult to believe this story.
Yes, this FIR is falsely implicated, wherein due to the illicit relationship which her ex-husband developed with the elder sister of the this
Any
complainant one.
medical examination report?
Medical examination is there, Your Lordship. However, with regard to, because she's already a mother, Your Lordship, those are not there. But Your Lordship, her statement on the after filing of the FIR was that she was given a juice, Your Lordship, and some substances were mixed, Your Lordship. The FSL were the Arunachal Pradesh Alto Hospital does not have any test with regard to narcotic, Your Lordship.
Okay, so that could not be asserted.
Yes. Now, in the statement of the husband, Your Lordship, in fact,
First ex-husband.
yes.
Now ex.
Yes, now ex. He had clearly stated that, in fact, they were the accused herein and the complainant had a relationship on an earlier occasion. However, subsequently they parted their ways, and the incident was told to him by his wife, Your Lordship, when he came back from the work. And the same was corroborated by the complainant too. However, on the later stage, Your Lordship, she has made an allegation that she was forced by the husband to file the FIR.
So when did they get?
That
say
is not there. Even the statement of the accused does not say that he got married to
married.
yes,
So this thing we cannot believe.
yes.
Yes, sir. What do you say?
Now they are living as a husband and wife. That is one part.
Okay, fine. Let them leave.
But
Now we have now our country, our thought process about how husband wife we have all changed. But for the criminal purpose, show me.
Lordship, here is the case. It is nature of this civil nature. Exactly, it is not allegation is no doubt 376, no doubt. But the
This
allegation,
Abidalam is the first husband.
even your Lordship, may I take your
Yes.
take your Lordship at page 10 is the annexure FIR, and FIR is also irregular, Lordship. FIR wherein
You are not challenging this on the ground that the FIR is irregular. You are challenging it on the ground of compromise.
that is one irregular part of the FIR. The date of incident was on 1 February 2022, and the FIR was lodged on 2/3/22. So therefore, Lordship, is this
This is in orders. Okay, we'll have it for admission someday. In terms of the directions passed by this court, quite ordered it at 5/12/2024. Ms. T. Ginny Learned, additional public prosecutor, has furnished the case diary in the matter. Full stop. This court has perused the case diary, and the same is returned case diary, and accordingly, this court at this stage is not peruse the case diary and finds that a case has been made up against the accused, that is the petition number 2. Also, the court is further not convinced with the mutual settlement, deed of mutual settlement brought on record as Annexure C, inasmuch as in the case record, it's not from the case diary, it is not revealed that the parties hereto have married each other. And as to when the initial marriage of the petition number 1 was dissolved. Full stop. In that view of the matter, the issue arising would require a detailed consideration, comma. Registry is directed to list these matters again in the month of when? February? February 4th for admission hearing. February 4th.
Meanwhile, Your Lordship, we call for updated CD.
Full stop. The CD case diary is returned with on the next date of listing. Ms. Ginny shall place before this court an updated case diary. Done with. Nothing. It took 5-1 day. 511.